Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
To a grand jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
Dati mihi Anglican for his verbal slaughter.
Is that correct?
I didn't ask you to interrupt me.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here this morning. It is a beautiful morning, actually. It's gorgeous out there. Hope it's gorgeous where you are. I realize a couple places got hit with tornadoes last night. Thoughts and prayers out for them, especially down there in Texas. Saw some terrible damage down there. Wow. You guys stay safe, please. Stay safe.
You don't put a diplomatic plate on a hoochie.
All right, we're going to be going to court in just a minute. We've got this one right here. We're getting set. We're almost there, but a few things to take care of first. I have to give away the internet, so I don't have to look after it. Let's see, who does that go to? Goes to Fran Fitzgerald. Fran, congratulations! You're first in chat, first in the internet. You're the owner of the internet. Sorry, that's in the way. Congratulations! Everything up here related worldwide is your responsibility. Thank you very much, Fran, for being first once again. I still have not gone to the post office. I apologize. I need to go. I'm blurry again. I'm going to focus. I'm focused. There we go. All right. Lots of, I need some, you know what? Hang on, let me call my kids.
Hello.
All right. Welcome.
Happy birthday. You look good.
We've got some birthday things to celebrate. We've got, why is that doing that thing? Why is it? Don't do that thing that it's doing. Okay. Not that one. Not this one. There we go. Not that one. Stop. Hold. Wait. Back. There we go. Okay. This one's good. There. All right. Now we're good. All right. Are you double miking? Yes, I am. I like the high end of this one and the sensitivity, but it's too sensitive for how loud I am. So let me sort of turn it a little bit, change the pickup pattern. I do double mic. Yes. It helps stop people from saying, "Hey, I can't hear you. Turn it up." But let's see. I have to read my milestone singing. Camilla says, "Let me do that. Let me do that first. As soon as we."
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. I need that water. That was longer than ever. I know. Sounds like it's the problem is every time I set the bar higher, then I just fail next time. It's hump day. It's Wednesday. We made it halfway through the work week. I need 2 more after this one. I need 5 waters. It is Wednesday, and I apologize. Deer Park not a sponsor, but we will take a nice, long, cool sip of refreshing Deer Park water. It's good on vocal cords, especially after a good hump day yell. All right, welcome. Thank you. Appreciate that. We are now fully stocked with water for the day, and we're ready. How can I get your stamina? You, too, could be able to do hump day yells like this if you drank exclusively Deer Park water. Not a sponsor, obviously, but couple things. Just making a public service announcement. If you go to Taco Bell and you ask for a cup to get some free water, don't get the soda. Do not get the soda. If you say you need a cup for free water, just get the water. I've seen a video. Let's just say Liv Moss was not what the employee had in mind when he drew down on the customer that was stealing soda from the water fountain. So water it is. No Liv Moss. All right, Taco Bell, also not a sponsor of the channel. Let's do birthdays really quickly. Thank you very much for getting those ready. Thank you. Who put those up? Was that Red? It was Red. Red, thank you very much. Appreciate you. So happy birthday to Emmy J, 78, Jamie's daughter, Kinsley, Jackie, and John M. Emmy J, Jamie's daughter, Kinsley, Jackie, and John M. We can sing to all these wonderful people wherever you are. If it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with the neighbor, and warm up with me if you will. La 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 la. It's good. We're gonna do this one. We're gonna rock it. Jamie's daughter is Kinsley. Okay, there we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Amy J, Kinsley, Jackie, and John M. Happy birthday to you. Kinsley, Jamie's daughter. It sounds like a Norwegian way to say names, like Scandinavian. Jamie's daughter would be your last name. Kinsley, happy birthday. Happy birthday. I don't know how old you are, but Jamie's awesome. So thank you. Imagine you're awesome too. Emmy J, Jackie, and John, congratulations. Lots of J's today. Everybody but Kinsley got a J, but at least Jamie is the parent, so we have lots of J's. Happy birthday. I realize there are many wonderful days, but today's your special day, and there are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. And that privilege, that pleasure, that honor, that is ours. But hopefully we can turn it back to you and make your day just a little more special. Or begin by helping yourself to some free pancakes at Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Why bottles? Can you get the big jugs and not go through as many bottles? Isn't it cheaper? I can, Sarah, but the visual during this portion it just wouldn't be the same. It wouldn't be the same. First of all, it would take like 3 minutes longer. And then I would have to take a break. So I can't guzzle it. 1 down, 4 to go. Happy birthday. Thank you all for the dancers. Appreciate it. Yeah. Let's see. Chugging from a 5-gallon bucket would be funny. It would, like the first time. My equipment would not think so. Drum solo for the big finish. Help me here. Air drums. I sort of went half-hearted on the little around the toms thing at the end, but all right. Lori says that happened at the Taco Bell next to me, the town over from me on Monday. That was down. You're in Florida, Lori. That did happen in Florida, and I'm not joking. 3 ladies showed up. Apparently, the story is they showed up, asked for cups for water, free water from the dispenser. They proceeded to go get soda, allegedly. And an employee confronted them. An argument broke out, and the employee drew his sidearm, which I imagine, I'm just going out on a limb here, probably not company issued, right? Probably personal. I'm guessing here. I don't have the facts, but I'm guessing it's personal sidearm. And proceeded to discharge said weapon in the store. One lady was grazed, fell down on the floor. The other 2 ran outside where he fired again for good measure, where a window was broken, and they all went to the hospital. Everyone's going to be okay. That's the good news. Well, almost everyone. The employee probably does not have a job today. That's my number 1. And number 2, he probably does have a court date. So that's exciting. Also in today's news, Yum Brands earnings tops estimates fueled by Taco Bell's 8% same-store sales growth. Oh, my goodness. Yeah, this they haven't factored in today's new or the most recent news in that. Florida is the wild, wild west. It's a crazy place out there. You gotta watch your back. You gotta watch your back. Be careful out there, people. Be careful. Anything can happen. To heck with the free pancakes on my birthday. I have T-bone steak and cheesecake, says Donald King. Donald, enjoy. That's yummy. I'm rating this channel PG-13. RA getting water wasted on. Okay, so too much. There's a thing is too much water. Let's see, Camilla. Let me. I'm not forgetting you. Camilla, I just read ahead, but let's not get ahead of ourselves. Melissa, Chris, member for 19 months on the jury. 19 months, where has time gone? Thank you, RA and Mods. I think you've been here a bit longer. OG! There you go. Also, speaking of OGs, tell me why. I can't do this one. You haven't hit the like yet. Don't make me call again. Yes, Camilla. Camilla does, if you haven't noticed, Camilla is, she has a sole purpose in life, and that purpose is to get this channel to 100 likes, or excuse me, 1,000 likes on every single live stream. And she's relentless. Not only is she relentless, some people would like, I don't know, program an AI bot to just send the command, hey, please click like or something. No. She incorporates whatever's happening in the trial at the moment, like on the fly, off the cuff, into a funny reminder to click the like button. Now that I've called it out, you'll see it. And Camilla, thank you very much for that. That does help the channel a ton. You are an OG. Speaking of huge, not huge, but like long-term OGs, Posty7, 40 months. 40, that's the big 4-0. I think this should come with like black balloons. Oh, I see you've already got one. Never mind. Well, it's sort of purple. Feeling 40. Wow. I know you're not feeling 40. You're fit as a whistle and ready to roll, walking around delivering the mail. So, Posty, thank you very much for being here. We've got a call coming in. I don't know who it's from, but it's on the burner phone, so let's take it live. Why not? What could possibly go wrong?
Call from
Texanne.
Texanne, our court watcher. How are you doing today?
Hey, I'm about to get out of the car and go in. I just wanted to touch base with you before I went in and let you know when I get word that they've got a verdict, I will send you a message.
Excellent. Or call me or something, just whatever you got. So.
Or call or whatever. But anyway, I just wanted to point out something. The video that you guys didn't see, it was an angled shot from inside the store. Mm-hmm. When the guy was by the taqueria truck, the taco truck, you could barely see him between the pole and the wall. On the upper left side of the screen, he was wearing a white T-shirt. Guy wearing a blue or black polo walked up from the middle of the right of the video. It appeared that they had a short argument. The blue shirt guy walked back into view and then off screen, followed by the plaintiff. The plaintiff had his arm extended downward towards his shorts. He was holding a pew-pew, forearm extended. Despite the proper gum etiquette, It was obvious that he was in possession of gum. We are all grateful that he did not chew it.
Right. No chewing.
No chewing. Another guy was following the plaintiff. He seemed to talk him down, in my opinion. He took the gun from the plaintiff's right hand, or the gum from the plaintiff's right hand into his left hand and proceeded to walk back to the left side of the screen.
That's awesome.
The door the lawyers went into was not the same door that leads to the judge's chambers. Her door is to the left of the flags. It's like the wooden panel opens up and it goes to her office, but she might have another entrance from that way. So
hidden
they might have went in.
Texanne, yeah, go ahead.
Real quick, the defense attorney's drink of choice is Mountain Dew. Apparently in increments of 3, none was shared with the client. He slurped down all 3.
If you get a chance to talk to him, ask him if he's tried the Dirty Mountain Dew, which is a cream soda flavor. Oh, my goodness, that stuff has got me. Oh. It is so delicious. Texanne, that was probably one of the... That was probably one of the best summation wrap-ups that covered everything we needed to know about yesterday I've ever had. That is incredible. Thank you. I will ask you about the video. If you could rate it on a clarity of 1 to 10, would you also rate it a 7? 10 being the clearest?
The video?
Yeah.
your video or
No, the one in court.
Video?
The court video.
Yeah, I mean, they could. They've got a lot of work to do, but maybe you could take a trip down here.
So the security video of the interaction with the gum, was that a clarity level? That was a 7?
Oh, that video.
Yeah.
Oh, you can definitely tell that he had gum in his hand.
Okay. Yeah.
And finger etiquette was perfect on it, but
okay.
that didn't help the fact that he was in possession of gum.
Yeah. Yeah, you got to be careful with your gum, or else it can come unwrapped really easily. Keep that finger parallel to the package. All right, Texan, we can't wait for you to go in there. It looks like they're just getting set. All the prosecution's there, the defense lawyers there, waiting for the defendant and the judge, it looks like. But we can't wait to get an update from you. Thank you very much. Appreciate it.
I'm wearing a multicolored shirt. I'll be sitting in the same place as I did before, and it's probably only me that's in there. Me and maybe one other person.
Awesome. Thank you. Don't tell them we're here, okay? It makes them gum shy. Gum shy. Okay, thank you. All right. We'll see you. Thank you.
All right, bye.
Bye. Oh my goodness, that was amazing. Her synopsis that covered everything. Absolutely amazing. Did a better job than any recap I've ever done on Verdict Watch, ever. Okay, bazooka bubblegum. That's what we're talking about, yes. Texan, our court watcher, will be walking into court here in just a moment. So we are trying to use some substitute words just because right now in this current, this current wave of interest, YouTube is doing YouTubey things to channels in a big way, and it hurts. It's something we can't risk. So we'd ask you guys to talk all about gum and blammies and pew-pews. Thank you for doing that. I'll try to do the same. We are visiting Beaumont, Texas. That's where we are. We're in Texas, Beaumont, Texas. So this court, day 1 was yesterday. We also had a day 0.5, I guess, and there was some stuff before that even. So we've had a little bit of a run-up before court actually started. If you're just joining us today, don't worry. You've only missed one witness. Now, that one witness just happens to be the entire case for the state. Here comes the defendant. There he is. Ooh, looking sharp. I like the lime green. It goes well with the Mountain Dew. Goes well with the Mountain Dew. I'm thinking that's great. Paula Mack, in exactly 72 hours, just Stephanie W. and I are meeting in Wisconsin. Not sure that the animal sanctuary will be the same after us. Good times ahead. I love that you guys are meeting up. I hope you guys have a great time. Please send us a picture of the meetup and enjoy Wisconsin. That's awesome. Paula Mack, thank you for your generosity as well. Okay. Let's see. We're in Beaumont is in Jefferson County, right? Somebody can confirm that, right? Jefferson County. I want to make sure before I show these pictures that I'm showing the right ones. Yes. Jefferson County, Southeast Texas. All right. Give me a second, because this courthouse is straight out of a movie. And you'll see what I mean here in just a second. Let me get this transferred over. Please be upright. AirDrop to my Mac. Pull up my switcher. Media. Okay. Here we go. That's going to go right there. Check this out. While we're waiting for court to start. This courthouse is straight out of a horror movie. Can you imagine this thing in the dark with the big, like the 3 eyes there at the top? I guess they're windows, but they look like 3 eyes looking down on you with these massive doors. I don't know who designed this. It's beautiful architecturally. But I think it was Stephen King. I'm just saying. I just think that might be the case. It was not what I was expecting when I saw this interior of the courthouse. So you've got the Starship Enterprise on the inside, and you've got this on the outside. But it is, in fact, beautiful. I love the old architecture that we find in courthouses. Absolutely amazing. Let's see. We have pictures also submitted of Amigos, the restaurant. It looks like it was taken from the other side of the border. It's a funny picture. I'll see if I can share that in a minute. Cody Hype, member for 10 months, says, all this talk of gum makes me think of Roddy Piper. Here to chew gum and kick butt, and I'm all out of gum. Yeah. I appreciate you changing that saying to fit our rules. Looks like a 1950s high school. Yeah, that was an era where all government buildings sort of look the same. It's funny because we have a government building in Kinston. I don't know if it's the courthouse or what, but it is straight on. There was one architect who looked at all the needs for government buildings and said, I can give you a special. I can give you one building that can work for everything. It will work for your courthouses. It will work for your jails. It will work for your prisons, and it will work for your schools. And they're these blocky, cement, flat-faced buildings with long, narrow windows, all with bars on them, because that was just convenient. That way you could change it from being a school to a prison or a courthouse or something else. I'm not a fan. Not a fan of that. But see Carol Houghton, Florida's recent post here. Deer Park sent you an advertising text to your channel. Are you serious? Where? On what? Where is this at? Where is Deer Park's advertising text? Hang on. I'm looking. Was it to the burner phone? I've been waiting for this all my life, guys. The idea that we may have a sponsor for water. When did this one happen? I told them you're not interested. Oh, okay. That's me guzzling from a gallon container, spilling all over my red shirt. Is this AI? That's funny. That's funny. I think it's AI. It's hilarious. I don't remember that ever happened. I don't remember A, spilling over my red shirt, or B, drinking out of a gallon size. Maybe it might have happened once. Oh man, I really like the combo, the tie shirt combo. I just saw that, Mr. Attorney. Dark suit, maroonish shirt, and the tie that ties them both together, quite literally. Oh my goodness. Let me read that text one more time. Deer Park sent you an advertising text to your channel. I think it's the image that you're talking about. Is that the one you're talking about there? I'm not looking for like a please sponsor. We'd like to sponsor you thing, right? You got my hopes up there, Carolyn, Florida. Let's see. Here comes our court watcher, I think. Tisha S., member for 24 months, says, I'm the lurking queen, but I promise I'm still here. OG Tisha S. Thank you for being here. Appreciate that. We find out today when Caleb Flynn is going to start. Yes, they did ask for a 21-day delay. Let me give you an update, though. I actually got an update from the court PIO in the Corey Richens. I said it right. I didn't say Karen Richens or Karen Reed or anything else. In the Corey Richens trial, the sentencing is going forward on the 13th. There will be no public seating available. Zero, unfortunately. No public seating. Media is extremely limited, and I have to tell them right now if I want to be there in person, and I think they're like 5 seats. Only people who are on the media row will be allowed to bring any sort of laptop or something like that, so you can't come in and sit with the family as a media member and get in. What this tells me is this tells me that the family gets all the rows. The families get the rows, and so the family will choose who'll be there. Now, if the family decides to bring somebody in, like our court watchers or something like that, that's up to them. But I can't get anyone in through media access. All right. Let's see. Caleb Flynn got the delay. I know he got one delay. Did he get the big one, the 21-day delay? Let's see. Waiting for the judge, waiting for audio. Court watcher is present. Hello. Hello, Texan. Right there in the center between the two desks. All right. Can't imagine wanting to watch that kind of emotion in person. Oh, you're missing out. You're missing out. It's something else when you walk into the courtroom in person. We're going to wait to get it confirmed. There have been 2 delays that Caleb Flynn asked for, and the first one was granted. I think it was just yesterday they asked for a much bigger one. They're saying he got the 21. That pushes out a month. That pushes it all the way to like June. Is this a replay of an older trial? Nope. This is live out of Texas. All right, I think we're about ready to get started. They were supposed to start at 9 o'clock, but apparently the judge is on my schedule. I've been very late recently, and so I can't really call her out, and without getting a little egg on my face. So I can't complain. We'll live with it. Yes, Romeo Johnson, the defendant, in green, with his head down right now. I'm not sure if he's resting or praying. Could be both or either. Was acquitted in a murder trial earlier with the same judge, with the same defense attorney, with the same prosecutors in the same courthouse. He was acquitted of murder. And then as soon as he was acquitted, he was recharged, even though it was like years after the event, with being a felon in possession of a firearm. This case has been unique in that defense has only twice, out of all the objections and all the confrontations and arguments in front of the judge, only twice has had the judge side with them, and even then it was weak. This has been a one-way show for the most part. So we're just waiting for the judge now. Yes, it was his own testimony on the stand where he said that he was in possession of bazooka bubblegum And there's a video, a blurry video, obscured video that shows it. So defense is taking their case in chief today. We're going to see if the defendant takes a stand. The defendant has previously, at least according to his defense attorney, planned on taking a stand because in his open he said, "You're going to hear from my defendant that what, X, Y, Z." All right, here comes the court staff. Bring the phone. Got to have the phone before you can work. How else are you going to text?
Good morning, everyone.
Good morning, Judge.
All right, let the record reflect. State's attorney's present, defendant and defense counsel are present. Before we get started, a couple of things. The first is Ms. Tanner emailed you both excerpt from the transcript from that trial, from the previous trial. Two things. One that I think Mr. Wilkerson had requested, and then I had requested her also find and transcribe for us the admonishments before Mr. Johnson testified in that trial. And so with regard to any request for any type of in the charge, anything having to do with voluntariness of that statement, if that's still going to be a request, then what I probably would do if I deny that request is make the part of that transcript a court's exhibit to send up to show that he was admonished on the record by you, Mr. Wilkerson, and also I followed up with some questions as well. So we'll get to the charge after his testimony this morning, if he still intends to testify today.
He does not, Judge.
He does not?
That's correct. After further communication regarding the matter, he is not going to testify in this case.
All right.
Regarding the voluntariness matter, what I would suggest to court is that while admissibility is court's decision, weight is for the jury to determine. And then relevant to optional completeness regarding the two pieces of the transcript, the court, I believe, was indicated in intent to seal one and send it up. I would also, as an offer of proof, ask that the other exhibit regarding cross-examination also be sealed and enclosed, Judge.
I'm not going to seal that and enclose it. If you want that read to the jury, then you can bring, it's certified. I've already said that I would allow something, Mr. Coleman, you can take a look at it. But the thing is, I'm not denying that now. So now I'm obviously not going to allow the whole transcript, but I gave you that opportunity to get with Ms. Tanner. You did. She did that. So if you want that portion in this trial, I'm going to allow it. And so there is nothing that portion needs to go up unsealed or sealed or with an offer of proof or anything like that.
After you meet, Judge, I haven't checked my email. I haven't seen it. And
so this is, hold on. So this is the, these 2 pages are the admonishment with regard to him. And then you can probably, it won't take you long. I'll give you a minute to go through that. While you're doing that, Mr. Coleman, I'm going to just put something on the record with the defendant. Mr. Johnson, would you stand up, please, sir? Would you raise your right hand? Do you swear or affirm the testimony you're going to give will be the truth, the whole truth, and nothing but the truth?
The other right.
All right, you can put your hand down. And so yesterday, Mr. Johnson, I gave you an opportunity to visit with Mr. Wilkerson in the back for a little while regarding whether or not you wanted to testify in this trial. And when you guys came out, you made the statement that you did want to testify and had planned on doing that today. And then he has said this morning that you have changed your mind about that. Is that correct? Yes. So is it your position that you do not want to testify?
Yes.
All right. You can have a seat. Also, I was going to let you know before that testimony, and if this changes anything, I'll give you an opportunity to visit. If Mr. Johnson takes the stand today, then my thoughts, obviously that leaves a lot of things wide open with regard to convicted criminal history, also bad acts and things like that. I do think at that point, it would probably be fair game to discuss the murder trial, the facts of it, whatever, within some parameters, because we're not going to retry anything or anything like that. But that the ruling that I had so far with regard to not discussing that, I think would probably go away, and that if he took the stand, could be considered a prior bad act still, even though it's not convicted. And either of you guys could use it however you want it. Does that change anything?
It may, if I could have just
you need to talk.
Yeah.
3 minutes to discuss the claim.
Yes, Mr. Coleman, did you have something?
Once we go out to the transcript, but after I can wait, or we can take it up now if you want.
Go ahead.
Your Honor, there is a self-serving statement in here that the defendant made. It is on page 7, starting at line 19. Well, the thing about me is I've never been one to carry a weapon. If defense counsel is putting this into evidence and will argue that to this jury, I think the state's entitled to put on rebuttal testimony, Judge, about the fact that he's never carried a weapon. We have a witness here who will say that he was robbed at gunpoint by this defendant. And I think that I would ask the court to allow us to put that testimony on to rebut that statement.
I think that would probably open the door, if you put it in with that statement, that if there is some rebuttal that he has in fact been seen with guns or certain offenses or whatever it was. So that you might want to discuss that as well.
And one last thing, Judge, he does have a 2015 robbery, which I am not acquainted with or familiar with the underlying facts. Again, if that involved a firearm, I would also ask to put that on as a rebuttal testimony.
All right. So I think those would probably be potentially fair game if this statement came in. And so before we put it in, or you asked to put it in, why don't you take maybe just 10 minutes or so, visit with Mr. Johnson, try not to do any more than that. If you'll let the jury know, it's going to be about 10 more minutes, please. Actually, yeah, tell them 10 more minutes, but then we'll also have to make sure the charge is right. So why don't you go ahead and do, because the charge is done.
20 minutes.
Other than what we need to talk about, go ahead and do about 20 minutes. All right, y'all go quick. The quicker you do that, the quicker we can know what we're going to do.
Yeah.
Thanks. We'll be in recess.
All right. So this morning, defense lawyer changes his tune, says the defendant does not want to testify. Then the judge comes in and says, "Oh, wait, before you make this decision, just let me tell you that I changed my mind, and I am going to let you bring in more of the transcript from the murder trial if you testify. And, well, I'm going to let you bring in more of the transcript from the murder trial. And if you testify, I'm going to let you talk about what the trial was about. Basically, open that can of worms." Defense says, if you bring in that bigger part of the transcript and it has that part that says, "I never carry a weapon, I'm not one that does that," then we want to bring in prior robberies and another witness that says he does carry a weapon, and it's going to get really, really messy really fast. I'm pretty sure that our defense is pretty much just going to rest right now, because I can't see them winning going down either of those roads. Yes, they want the wider statement. They would love to have that statement in saying, "I don't carry a weapon. I'm not one to carry a weapon." But that will open the door to testimony where someone says, "Liar, liar, pants on fire," and if they have proof, then that's terrible. And prior convictions for robbery, things like that. That's all. It's all coming in. Why do I always listen to Judge West with her charming Southern drawl why do I always want to repeat Judge West with her charming Southern drawl when I listen to her? Because the Southern drawl is probably one of the easiest accents to emulate. Why did my phone not like the word drawl? I knew what it was saying. This is live out of Texas right now. Judge West doing her thing here. In Michigan, that charge can get you 5 to 7 years. Yeah, this is not a light charge. Possession of a firearm by a convicted felon. I don't remember the actual penalty stuff. And I have not read Sarah Boone's most recent appeal stuff. It's typed. It's typed. I'm used to reading her stuff in handwritten form. I think it's typed by an actual attorney. So we'll see. Let's see. 20 minutes. Those are Mountain Dews. He brings Mountain Dew to court. This guy is like amped up. How's everybody doing today? I was going to share a story with you today, and I can't remember what it was. It was an important one. It was actually unimportant. But did you see the soft sit? Yes, we can probably go back and watch that right now. Josh, is it 20 minutes long? Or is it longer? There was a soft sit in this court yesterday during the filler part that somehow we missed. It was an embarrassing story from 8th grade, I think. No. From gym club? No, it wasn't that one. It wasn't that story. I'm pretty sure. Less than 20. Okay, give us a sec. Let me find... That's not it. That's not it. Let me look in mod chat so I can get the instructions again. Mark. Okay, got it. Let's go up here to 32 minutes. All right. Quick break while they have a break. We're going to keep the audio from that other court on, and we're going to keep the audio from both on. That one. Nope, that one. Okay. Audio follows video. Here we go.
Nasir Brown.
This happened yesterday. Thank you, Josh, for this one. We'll be back with live as soon as they're done talking.
Good morning. Are you Nasir Brown?
Oh, he's ready.
I'm appearing here today on special appearance.
I'm sorry. Speak up so I can hear.
Here today
You're appearing here today?
by special appearance.
Okay. What is your name?
I'm a third party intervener on behalf of artificial legal entity Nasir Brown.
Okay. At one point in your at some point in your life prior to being this third party, were you Nasir Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you've now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
I have the challenge subject matter jurisdiction going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026.
Yeah.
And so since you have
Soft
made
sit's not
bond
gonna
and
help
got
you.
out of jail on your cases, have you had an opportunity to try to hire a lawyer?
Is this what I'm saying?
Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else, I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? I'm sorry?
Overstay.
Say it again.
Overstay.
You overstand?
Yes.
Okay. What does that mean?
Overstay.
Do you understand what I'm saying, sir?
Not blind.
You'll oblige?
Oblige. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well? You overstand. I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk.
Is that it? Is that it, Josh? We might have to watch this.
Kyle Whittington.
Yeah, we might have. Kyle Whittington? Like the football coach? Hang on. No.
Good morning, sir. You're Kyle Whittington.
Yes, ma'am.
And Mr. Whittington, were you able to get an attorney hired?
I wasn't able to get. I actually lost my job because they're actually trying to give me
Not the
like
football
move,
coach.
like hazardous waste without any like material dockets or like that. So I had to quit.
I can't understand what.
I had my job. I lost it because like I had to quit because like they were wanting me to move like hazardous materials without any type of manifest or anything like that, and I wasn't gonna risk my going to jail. So I had to quit.
Okay, back on the record.
I'm actually in the process of getting a
And
job.
Okay.
why would
sorry,
that have
sorry.
made you go to jail?
Because like if someone got a
Mr.
ticket, we got
Wilkerson.
like violated my bond fee or whatever, they're getting another ticket or something like that. I don't know if it would, so I just quit. Well, it's like it was too much of a risk. Like they were ready to make me do all kinds of stuff. Like I didn't think it was legal. So
Where were you working?
Hydrocon.
Hydrocon was trying to make you move hazardous materials without a permit?
So have you
They're a
tried?
very shady like company. I did not like it at all.
I'm going to have you fill out some paperwork to see if you qualify for a court-appointed lawyer this
All right,
morning. You
we're
need
gonna
to fill
jump
it out
back, 'cause they're
accurately
back.
and completely. You're going to need to swear under oath that it's all true and correct. You'll step in front of the clerk on the end. She'll give you
Just
that
out of
paperwork.
curiosity, whenever I'm still get a lawyer, like I'm still a hire lawyer. Like whenever I get the money, like I gotta like just swap them out or
Can you afford an attorney?
yeah, eventually, yeah.
Eventually when?
Like if maybe like in 30 days or so.
Okay, so you've been here 4 times
Right.
and you've been given all this time.
Yeah, I was in the process of getting that new job that I found out was shady, right?
But what I'm saying is, if you don't have a job right now, are you going to be able to afford someone if I give you one more reset, or do we
Yes.
need to go ahead and?
Yes, I would.
Okay, so I'm going to reset your case 30 days. You need to have a lawyer before that next court date.
Good thing.
Right? Step in front of the clerk.
All right. Here we go. We're back. We are back. Let's hit the play
Charges
button.
arose from and the
Hang on.
the
Wait, wait.
discussion that ensued.
Okay, they're back.
As
We'll catch up on the next break.
Okay, back on the record. And Mr. Wilkerson's been given an opportunity to visit with, have a seat, Mr. Johnson.
Back to
And
live.
so where
almost.
are we now?
Judge, given court's consideration of the underlying issue of where these charges arose from and the discussion that ensued during cross-examination, we do want to both proceed with the defendant taking the stand as well as
he's going to take the stand,
as well as offering this exhibit. The state, though, has represented that it intends to offer a witness in rebuttal, which then will require me to put a 911 call into evidence and also further speak with law enforcement
Mr.
officers.
Wilkerson, just stop what you're doing.
Calm down.
Stand up. Tell me what you're trying to tell me without doing all the other stuff.
Okay, that will also require me to speak, to put on testimony from another law enforcement officer regarding the investigation in that case.
So do what you're going to do first, and then
too many
depending on what the state does, then if there is further something else that you need to do after that I find relevant and admissible, then we'll do that then.
Okay, I just don't want to rest and provide an opportunity for rebuttal and not be able to reopen the case to present
once you rest, you can't reopen the case.
Further evidence on that underlying impeachment matter.
But if you rest and he then puts on rebuttal, then I would allow you, I mean, we're not going to keep going down that path, but I would allow rebuttal one time, depending on what it is. And so obviously you can't put it on first. So that's the progression that we'll take.
One other thing, if I may, Your Honor, I'd like to also point out for the court's information that on that excerpt of the transcript that defense counsel would like to enter, page 8, line 5, line 6, the defendant makes reference to the fact that he has never been charged with robbery. Again, that's the statement that we want to rebut with the conviction documents that he has been adjudicated once as a juvenile for robbery, which it looks like it was a TJJD trip for, and also as an adult in 2015 conviction for robbery as well.
Yeah,
all right.
That's under oath.
So what we need to do then, I will get Miss Tanner, if you can get that excerpt separated out from the courts, and then we'll take a quick break for you to do that, and then that way we can get that in.
Miss Tanner, make it happen. Okay, this is getting messy. Defense attorney is wired this morning, like 5 Mountain Dews deep wired. He is something else trying to get organized. A little bit anxious. The judge had to be like, okay, hold your hands in pockets, don't move, look at me, don't pay attention to anything else, just talk. Holy smokes. This might not be maybe he's sponsored by Zantac. I don't know. I mean, that's like, that level of anxiousness is going to give you an ulcer. As will the Mountain Dew, I guess, if you drink too much. I don't know. Mountain Dew, not a sponsor. Let me say this. I don't know if Mountain Dew would cause an ulcer, but it definitely can't be good for you in large quantities. Zantac or Xanax. So he's back on the stand. Defendant says, yes, I will testify again. We're still fighting the repercussions of what that, what ripples that shockwave, that rock in the pool is going to cause, going back and forth with what doors get opened. This could get very messy very quick. He should not take the stand. I think his defense lawyer talked him into it. Shelley, the defense lawyer definitely feels that being able to bring up that conviction and that he was found not guilty, if he can get that in, he thinks that's like the golden ticket. But man, if bringing that in also brings to light to the jury's knowledge that in the last time he was on the stand for his last trial under oath, he said he'd never been tried for robbery, never even been charged with robbery, and has been convicted of it twice. That's a high price to pay. It's like, oh wait, you lie on the stand, then If you were, are you lying then or are you lying now? What does regular Mountain Dew taste like? Close your eyes. Imagine waking up in nature in a nice, cool mountain setting. Light breeze in the trees. Bit of dew on the grass. Birds singing in the trees.
Okay.
Tastes nothing like that. It's not actually Mountain Dew. It's like a lemon lime citrus drink. So with the hangover, possibly.
I'll tell him to bring it in.
It's very sweet. I really.
Can you bring center to print it, please? Thanks.
Judge orders a large pepperoni really quickly.
Okay, so before the jury comes in, they're bringing that copy of the transcript. Mr. Wilkerson, you can mark it as defense exhibit, and then we'll get it introduced either in front of them or now and admitted, and then you can do what you want as far as reading it or yourself to the jury or whatever, however you want to do that. Thank you.
All right. Good times.
Here it is.
All right. Copies for everybody. Amber's mom says I prefer Sprite as Mountain Dew is way too sweet. It is. But man, have you tried the dirty Mountain
stickers
Dew?
Are
it's probably even more sugar. But it is something else. Oh my goodness. Even my wife likes it, and she's not a big Mountain Dew fan. I can't do Baja Blast. My kids like that one, and it's like, yeah. What I want to try is
I think it might be easier to go through this with the defendant while he's on the stand, since he is taking the stand in this case as well.
I mean, we just need to get it admitted first. So this is defense number one, which is the transcript portion that you had requested. Mr. Coleman, any objection?
No objection.
Defense one is admitted. If you'll just leave it up here and then however you want to read it with him, with you, that's fine. I've got another copy that you can provide to the defendant.
And Judge, I guess it goes without saying, but I would be remiss if I didn't mention it. I would just ask that it be read word for word, the transcript.
Oh yeah, so the reading of it, if you do it with Mr. Johnson, it's very important if we're just reading it, that it is absolutely word for word. There's no explanation in the middle or anything like that.
Says
you
the
read
guy
it,
who-
then you can ask questions about it and things like that. So it's very important, Mr. Johnson, if you're reading your part, that you just read exactly what it says, okay? Okay.
the prosecutor completely
All right,
bungled
anything
that
else?
yesterday. The word for word bit.
You can bring the jury in.
All right, it got back interesting. The one thing I want to try, I was telling you, a Mountain Dew, a dirty Mountain Dew float. So vanilla ice cream with dirty Mountain Dew. That would be good.
Yeah. Do you have an extra copy of that, or do you need this one?
I have a copy that he can reference, from the packet that was prepared.
Okay. Yeah, that's fine.
So, and since the excerpt includes the client testifying in his own defense, so we'll start there.
Mountain Dew was originally created as a mixer for whiskey. You know it's good if it makes... No, never mind. Never mind. Don't think I've ever tasted whiskey. What? Don't shush me and spare them. Oh. Bless you. Who's shushing me?
Hush! Now I'm trying to have court. Don't raise your voice.
What does the Dirty Mountain do? It's funny you should ask. Let me tell you. Give me a second. I'll get to it. I'm not forgetting. All right, here we go.
Oh, makes sometimes, yeah.
Is that a paper sound or is someone going shush?
They're looking for one juror.
You need all of them, Judge. Okay. I think I fixed it. I'm still getting there, guys. Don't go anywhere.
Morning.
All right, here we go. All right, that was a long wait, but that's Dirty Mountain.
Good morning.
Good morning.
Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. Mr. Wilkerson, you may proceed at this time. Call your first witness.
Thank you, Your Honor. Defense call Romeo Johnson.
Mr. Johnson, come on up, sir.
He's like, you sure? He's like, yeah, it's all good. Brown Barn, wow. That's pretty cool.
And Mr. Johnson was previously sworn. And Mr. Johnson, just make sure you speak loudly and clearly into that microphone so everyone can hear you. And if it's a yes or a no question, be sure to say yes or no, not just a head nod or no. Okay.
Yes, ma'am.
Thank you. You may proceed.
Thank you, Your Honor. And just for clarification purposes, I think the jury should know that in their absence, Defense Exhibit 1 was admitted, which is a transcript from, or a portion of a transcript rather, of a prior proceeding. And so, Mr. Johnson, what I'd like to do first is to go through this transcript with you. I will read the court parts, my parts, and also the prosecutor's parts. What I would like for you to do, similar to Mr. Coleman questioning detective about the other excerpt from that proceeding, where answers are provided, where it says A, I would like for you to read those answers after I read you the question. You understand what I'm asking?
Yes, sir.
So you play you, I'll play everyone else. Let's begin. Scene 1. Prosecutor enters, strikes a pose.
Actually, all right, so
and says,
we are starting on page 6. And section cross-examination by Mr. Coleman.
The page numbers at the top right.
This was.
Other right.
You said you were a tax collector. You told the detective you were a tax collector?
Well, sir, that was 10 years ago. That was 10 years, but I will tell you about that.
So you understand that tax collectors work for the IRS, right?
I do understand, sir.
Hold on.
Oh, I'm sorry. I do understand that.
So it's very important that
Yeah.
you read it exactly. Otherwise, Mr. Coleman can read it. I mean, Mr. Wilkerson, or we can have someone else help read it if there's an issue. So it's very important.
All right. So what type of tax collector were you, even if you didn't work for the IRS? And then I object to characterization, Your Honor, and also there's a tax assessor collector in this courthouse, so it's in terms of the court.
All right, so neither of y'all are reading it word for word. Do y'all want me to read it?
Yes.
Sure. That would be.
Question. We're going to start off cross-examination by Mr. Coleman. Question. You said you were a tax collector. You told the detective you were a tax collector? Answer. Well, sir, that was 10 years, but I will tell you about that. Question. So you understand that tax collectors work for the IRS, right? Answer. I do understand that. Question. All right. So what type of a tax collector were you if you didn't work for the IRS? Mr. Wilkerson. Objection to characterization, Your Honor. And also there's a tax assessor and collector in this courthouse. So just in terms of the court, overruled. Mr. Coleman, that's what redirect is for. Question by Mr. Coleman. Okay, you understand tax collectors work for. Answers. Yes. When I said tax collector. Question. There's no question in front of you. And if there is a question, the court. Hold on, just ask a question. Mr. Coleman.
This
Yes,
is why
ma'am.
we can't talk over each
Question by Mr. Coleman. You understand that tax collectors work for the IRS, yes or no? Answer. I understand tax collectors work for the IRS. Question. So what kind of tax collection were you doing? Answer. It was more of, it really wasn't tax collecting at all. Question. Yeah, it wasn't, was it? What you told detectives was you used to be somebody that would put something on someone. Is that what you told them? Answer. I said that. Question. Yeah. And what would you put on them? Answer. Well, the thing about me is I've never been one to carry a weapon ever, but it's 10 of us in our house, and this is all we ever had, indicating. This all we ever use, indicating. Mr. Coleman, and for the record, he's raising up a clenched fist. Answer. I'm showing my fist. Yes, sir. And back then, it wasn't towards elderly, kids, or cripples. We had a code. But if you was back then with somebody playing like he was bad, you know, young, around our age, playing like you was bad, we was coming to show you that there was somebody badder. That's what I mean by tax collector. We wasn't taking anything. That's why I've never been charged with robbery, because they had people that was working who thought they was bad. That's why I've never been charged with any weapon case or anything. We didn't use weapons. I've never used a weapon to harm anyone. All I had was these, indicating. And I don't think I even used these to even put anybody in the hospital. That's half the people that I did that to back then were some of the closest friends now. Yeah, question by Mr. Coleman. They weren't paying taxes because they were older. That's what you told the detectives, right? Answer. They wasn't. No, sir. I said, well, as I just informed y'all, it's a code. We don't do anything to older people, kids, or cripples. We don't. It's still street. It's an unspoken code. Them people, you do not respect for them that. You got to have some type of morals. Question. On that, you and I agree, Mr. Johnson. You've got to have some type of morals. What did you do with those taxes? Well, let me just back up. Paying taxes. Paying, to me, that would imply that someone gives you something or you take something. Wouldn't you agree with me?
He was collecting
Answer.
rents.
I would agree. Question. And when you say that they paid taxes, in what form did they pay it? Was it in money or was it in drugs? Answer. Neither. When I said paying taxes and I say we put these on them, indicating, that's what I mean. Not taking anything from you, but we put these, we tax you with these. I'm sorry that that was received like that. But what I mean by taxing somebody is we tax you with these hands. You know what I mean? So I was somebody, I go get it. We was a tax collector. I go tax you with these hands. That's what it is. Stay in your place. You're not badder than me. I'm badder than you. Type of macho thing 10 years ago. My mind's been transformed.
Imagine how long this would have taken if the judge hadn't stepped in to read those.
Proceed.
How does this help him?
Mr. Johnson, in this proceeding, well, first of all, I want to touch on something. In this proceeding, you said you were never charged with robbery. What did you mean by that statement?
I mean, I was never charged with. I've had a robbery charge, but I was never charged with aggravated robbery of any weapon. And the robbery charge that I was charged with was behind some helpers. And when I was charged with that charge, I called the officers, and I still got in trouble because, well, I was on the phone with my sister getting the pampers. I didn't know that the pampers had different sizes to them.
What?
So that charge, that's back in 2015.
Yes, sir.
Correct.
Did anyone get that?
Right. And so with regard to this prior testimony, in the underlying case, was this where you took the stand in your own defense?
Yes, sir.
And so during the state's, in that particular case, you decided to take the stand against the advice of counsel, right?
Yes, sir.
And in that case, this exchange takes place during cross-examination by the prosecutor.
Yes, sir.
In that case, when you say you've never been charged with, are you meaning convicted of an offense involving a firearm?
Yes, sir.
Because in that case, the underlying case where you were testifying, what was that charge?
Murder.
Whoa.
And as we sit here today, you have not been convicted.
No, sir.
In that underlying charge, you were acquitted. Is that accurate?
Yes, sir.
And so you also have some other criminal history. Tell the jury about that.
I have criminal history, mostly for, I was a druggie back then, years ago, and mostly for drugs and evading arrests on foot. That was just one of the things when I came up, it was one of the things I didn't have anything to do with nothing. I just hear that beep, beep noise and take off running. And I almost got caught every time, so I couldn't have been that fast. So, but mostly it was drugging and evading arrests, but I didn't have a violent history. I've never been charged with any aggravated crime, any assault crimes, any discharge of firearms, any firearm charges, any weapon charges, period. But I wouldn't the best of person, but I wasn't the worst of persons either. Mostly I was hurting myself.
Hold on. Become a narrative at this point.
Sustained.
I want to be clear because you keep saying charged, and I think you're thinking about it in terms differently than the legal terms. When you say charged, you're meaning you haven't been convicted of?
I have been convicted of
any violent offense?
No violent offenses. I've never been convicted of violent offenses. All offenses I've been convicted of are offenses that when I was charged with them, I didn't fight. I didn't go to trial. I knew that I did wrong, so I took my offense like a man, did my time, and came out.
I want to ask you to elaborate a little more. In the transcript I just read, you're cross-examined about a statement that you made to the detectives about being a tax collector. What specifically are you talking about there? I mean, are you talking about taking something from someone?
Not taking anything. We had a term back then. There's 10 of us, so we had a whole bunch of terms in the house. And it's 10 of us, and and we was fighters, and you know, that's all they ever said was, "Boy, I attached you with these hands, I attached you with these hands," you know, and that's kind of where the term came from. But when I say tax collector, I guess they took it and used it in a way. Well, I guess he redirected the question to an actual IRS tax collector or somebody that goes out and extorts somebody. But that wasn't the tax collector I was talking about. When I said that, I was going back to when that's how we used to do when we would fight. We say, well, we didn't tax you with these things. And
When you say there were 10 of us, you mean siblings?
yes, sir.
All right. And you talked about a code. Can you explain what you meant by that?
Well, my dad is 79, my mom is 75. So we came up on the older people. We came up on the people that if you were doing something in your yard, they'll whoop your tail. So we came up respecting our elders regardless. And it was just a thing that back then, you didn't mess with cripples, you didn't mess with elderlies at any time, or you didn't mess with just kids. You know what I mean? You go get somebody that's about your size or a little bigger, and then you do that. But it was never to harm anyone. I don't think anybody ever was sent to the hospital. I've never had a case where it was aggravated assault or anything of that nature, even with someone my age. It was just a fight. And then after that,
Let me ask you, because you talked about it going out. So what types of situations would lead to this? Is this somebody felt disrespected by someone else?
Judge, I would object to the relevance to this exploration of the code and drilling down on it for the relevance in this particular case, proving up an off position of a firearm.
Sustained.
Defense loses everything.
This charge for unlawful possession of a firearm came after your acquittal for the murder charge.
yes, sir.
And when you were testifying, you understand that when you testified, you waived all of your rights against self-incrimination.
Yes, sir.
You did so despite the advice given. The video that has been shown to the jury. In that video, can you explain the sequence of events, starting with whoever it is that's walking up to where you're near, or from where you come when you come into open view of the camera?
Well, the day it was the video that was shown was for my birthday, and I was just a friend called me and said, "Hey man, happy birthday! Hey, come chill with me for a little bit." I said, "Okay, I'm coming up there with you." And
let me try and get you to step through it, because I want you to answer the question specifically, rather than you can't talk about what other people might say.
Yes, sir.
Okay.
Yes, sir.
So you said that it was your birthday.
Yes, sir.
And you said you were going to meet a friend.
Yes, sir.
Who was that friend?
Ethan Smith.
All right. And was it your belief that he wanted to see you because it was your birthday?
Yes, sir.
Okay. So at what point did you arrive at the store that is Amigos?
I'm not sure. I know it was late, maybe around 1 something.
So we're talking about early hours of the morning?
Yes, sir.
And just to be clear, Amigos, the store, is that closed at that time?
I'm not sure. I've never really just been to Amigos like that.
So, what was there? Was there a food truck?
There was a food truck
in that parking lot?
Yes, sir.
And was that food truck serving food?
It was.
And so, is that a spot
at 1 o'clock in the morning
congregate in because there's food there?
Right.
And so, when you went to that location, who brought you there?
A friend Justin Berry. He had brought me. We had been celebrating at his house.
Justin Bieber? Not responsible. Who brought you there was the question.
Okay, a friend.
All right. And
did he say Justin Bieber?
At what point, was your friend still there when this alleged altercation started? The friend that brought you?
No, sir.
All right. Do you recall about how long you had been at that location?
The Migos?
Yes.
Oh, not long. I wasn't even that long. We got there, I guess he was going get something to eat. Probably not even 15 minutes, I won't say.
All right. So in the video, there's an individual. Well, let me back up for a minute. When you are at that location, is there a point where someone approaches you?
Yes, sir.
And who was it that approached you?
I'm not sure of his name.
All right. What was he approaching you about?
Well, evidently the woman who gave me a hug and told me happy birthday was, as he clarified, and as I said before, he said his merchandise, hey man, don't be speaking to my merchandise if you're not buying. And I was like, what? You know, kind of stomach, like, what?
Don't touch the merchandise.
Now, at that point, you then see the same individual start to walk away. At that time, what is the exchange between the two of you?
Well, after he said that, he had walked away, and Ethan Smith was like, man, what he got going on? And I was like, brother, I don't know, but I'm finna go find out. So as I'm walking that way, even though it looked like I'm irrational, I'm not irrational. I'm not trying to fight him. I went over there, and once I explained what the situation was to him, unbeknownst to a lot of people, what he said was, oh man, I apologize. I thought you was in the life. Or happy birthday. And
so was it that a situation where you believe the person in the video may have misunderstood your intentions for being there at that location?
Yes, sir.
All right. And so,
it sounds like prime real estate.
So in the video, you heard the detective detail.
Not a good area.
That you are in possession of. Well, during the exchange, let me back up for a second. During the exchange that was previously admitted into evidence between yourself and the prosecutor in the prior case, you were asked about a gun several times. And you...
What was that?
You were asked if you could be seen giving a gun back to Ethan Smith on video. What did Ethan Smith give you?
well, when I was walking away, as y'all seen, when I was walking towards him, I had no weapon. I don't know them images. I had no weapon, no nothing as I was walking towards him. When he was going back, he handed me something as I was going to the car. I grabbed it. All I did was jump in the car. Boom. And then as he was finna back up, I told him, hold on. And I looked down. When I looked down, I called him. I said, hey, could you bring me my shirt? He brought me my shirt. When he brought me my shirt, I said, what is this? He said, it's not what you think it is.
to the hearsay about what he said.
Sustained.
Well, as he brought me my shirt, I gave him back what he had it to me. At the time, to me, it looked like a gun. Was it a firearm? I couldn't say. Was it a BB gun? I couldn't say. I mean, I don't think anybody could say what it was. I've never fired it. I didn't have it more than 5 seconds. Once he gave it to me and I seen what it was, I wouldn't even let my friend pull out the parking lot. I stopped him. Hey, could you bring this? Hey, man, I don't know what this is. I had no even attention to him even. I'm not even thinking I'm going back to the car. After me and dude set up what we had, I was going to the car to leave. I was still celebrating my birthday. It was the day of.
I want to ask you about one of the still images that's been admitted into evidence. Maybe if I'm smarter than that. There. All right. Now this is a picture of you when you're walking toward the person you had an exchange with. Is that correct?
Yes, sir.
All right. And it's alleged that you are carrying a firearm at that time or a gun. You've got on black shorts in this picture.
Yes, sir.
And this line right here, is that the,
Don't write on it.
out or is that the other the legging of your shorts?
Yes, sir.
All right. I want to show you what is in States Exhibit 6. This is you walking back to the car. Is that correct?
Yes, sir.
All right. And is this picture before or after Ethan Smith handed you something?
This is before.
It's important the jury believe this if he wants to be acquitted of this charge as
I
well.
want to show you State 7. In State 7, there's a silverish or grayish object in Ethan Smith's right hand. Is that?
Yes, sir.
All right. In States Exhibit 3, does that image contain an image of something silver or gray?
No, sir.
Well,
when you testified in your prior case, were you focused on whether whatever was exchanged at this store was either a gun or a firearm?
No, sir.
What were you focused on when you gave that testimony?
Just getting in the car and just getting away from there.
And so during that testimony, or the testimony that has been the excerpt that's been admitted, that and the other excerpt that we have subsequently admitted, both of those, were they part of a much larger exchange?
Yes, sir.
And was that because you were facing a murder allegation?
Yes, sir.
And then you heard Officer Carnouche's testimony before the transcript was even prepared. He filed a report on the statements contained in the transcript.
Objection.
As you sit here today, can you tell this jury one way or the other if you had, well, and I believe you said that you couldn't say whatever Ethan Smith handed you was or was not a firearm. To be clear, Ethan Smith wasn't called to testify in that case, was he?
No, sir.
And he hasn't been called to testify in this case, has he?
I'm not. No, sir.
Well, he hasn't taken the stand and testified to the jury.
Right.
Right. Okay. And in that, in your prior testimony, you indicated you didn't know what Ethan Smith would say. Is that correct?
Yes, sir.
And in terms of not knowing what he would say, is that because you're unclear about what you were even handed, or?
Yes, sir.
Does it go further than that?
Well, I know he's a convicted felon, but also, so that's why I say I wouldn't know what would he say if he was put against, if his back was put against some kind of wall or something. But yes, sir, that's what I wouldn't know what he would say at that time.
since there is no firearm in evidence, if the state wanted to establish its case that you were actually in possession of a firearm, then they have witnesses they could call to tell them whether or not that's a firearm. Is that correct?
Objection, Your Honor. That would call for speculation on the part of this witness.
Sustained. Don't answer it.
All right. I mean, we're at Officer Carmouche testified that he had spoken with Mr. Smith during his underlying investigation. Is that accurate?
Yes, sir.
In addition to the robbery, which you indicated revolved around Pampers, you talked about other criminal history matters.
Yes, sir.
In terms of, well, how are you doing with your addiction?
Objection, relevance, Judge.
Sustained.
Defense loses every objection.
With regard to talking about using your fists as weapons, is that
something you still do?
Would you say that that was associated with a street life or something else?
Ask and answer, Judge.
You can answer it just for him.
It's been well, I don't get into altercations anymore.
Just answer the question that he asked you. Okay.
So would you, again, the question was, would you say that was either associated with the street life or something else?
When I was using my fist?
Yes.
It was a street life.
All right. And just because jurors may not know what you mean by that, can you explain that to them? That characterization.
Oh, just friends that's, not street. You don't have to be, just because you sell drugs don't make you street or anything. You can be at work and still be street. Just friends that's what we did. And then as the time came, I was a big advocate for put the guns down, pick the gloves up. It's a
objection. This is turning to a marriage, Judge, and it's self-serving, Judge, and both her.
Sustained. Just be sure and answer the question.
Yes, ma'am.
Okay. So let me stop you for a minute. In the context of the street life characterization that you used for being street, does that involve congregating at odd hours of the morning or night?
No, sir.
All right. Are you referencing being part of a neighborhood where gang activity is present?
No, sir.
Are you referencing being a part of a neighborhood where there's drug trade?
No, sir.
And so when you say that, are you referencing a mentality?
No, sir. Just
objection, not responsive. It's yes or no.
Sustained.
And so what would you, how would you characterize what you're referencing?
Just like my mom been staying on Rivercrest over 30 years. It's just a Rivercrest street. I'm from Rivercrest Street. Somebody else might say I'm from this street. A whole bunch of workers. I mean, I wouldn't say it like that because that's how I would characterize it. Just where you was just born at. I'm from Rivercrest. Hey man, I'm off Tyler Street. It's just, when I say a street life, it's just the street. It's a street, you know what I'm saying? And it's just life. That's what I mean, not in any derogatory way that others would pinpoint it as such. Just street, it's just a street. Like, yeah, I know you
Pass the
Thank you, Mr. Wilkerson.
All right, buckle up. Let's
Showman.
see what the prosecution does here. Flips back 3 pages.
Let's clear up some things here. That was you on that video from September the 14th of 2024 at around 2 a.m., correct?
Yes, sir.
And that video took place at the Amigos restaurant on College Street in Beaumont, Texas, correct?
Yes, sir.
I just want to make sure we clear that up. You are the same Romeo Randolph Johnson who is charged in the indictment in this case.
Yes, sir.
And you can be seen with an item in your hand. And I know you dispute what that item may be or the characterization, but you can be seen on that video with an item in your hand at some point, correct?
There's a towel in my hand and a cup.
Yes or no, Mr. Johnson?
I'm just trying to get you to be specific about the item.
Not trying to trick you, not trying to trip you up.
Yes,
Well, you've listened to the testimony, you know what the focus is in this particular trial. You at some point were seen with an item in your hand, right?
Yes, sir. It was handed to me.
Okay. Now I know you dispute this characterization as an altercation, but you got into a back and forth with this other person, right? Yes or no, Mr.
No, sir.
You didn't take that towel and swing it around. You didn't storm after that person as he walked away. We don't see that on that video.
Sir, you see.
No, it's a yes or no, Mr. Johnson. We've been down this road before. And
Yes,
you know
sir.
how I
Yes, sir.
operate.
Yeah.
Questions I am going to ask you for the most part will be yes or no questions. And I'll thank you to answer yes or no.
Yes, sir.
Did you storm after this person after they walked away?
No, sir.
Okay. If this jury saw that on the video and they interpreted it that way, would they be incorrect?
They have their own interpretation.
Fair enough. And if Officer Carmouche says that what he believed he saw in your hand was a firearm, would Detective Carmouche be incorrect?
Yes, sir.
Okay. And if this jury in their interpretation believes that what they saw in your hand was a firearm, would they also reach an incorrect conclusion?
It would.
Yes or no, Mr. Johnson? Your attorney will have the opportunity to come back.
Here's how it works.
I won't talk over you. You don't talk over me. Anything that you would like to elaborate on, your attorney has that opportunity. But for my part, I'd ask you just to answer my questions, yes or no.
Yes, sir.
Again, if this jury reached that determination, would that determination be incorrect?
Yes, sir.
Okay. Now, you had an opportunity after what happened at Amigos in that parking lot to sit down with law enforcement for an interview, correct?
Yes, sir.
And during that interview, did you tell law enforcement anything about you not knowing what was handed to you, or disobeying somebody being in a foul? Did you mention any of that to law enforcement?
No, sir.
Okay. You had an opportunity at the prior court proceeding back on October the 9th of 2025, when there was at least no less than 6 references to a quote unquote gun, to explain during that time while you were under oath that you briefly was handed a towel that had something wrapped in it that could be a gun, but you didn't know. You had an opportunity to explain that, yes or no?
Sir, I don't remember the question about a towel. No.
Let me ask the question again. When you were asked about the gun, you had an opportunity to say at that time what you testified to this jury today about, correct?
That was handed to me?
Exactly what you testified to today. You had an opportunity to say that at that time back in October of 2025, correct?
And I did, sir. Yes, sir.
Thank you, Mr. Johnson. You were on your oath at that time, correct?
Yes, sir.
Just like you're under oath today, right?
Yes, sir.
And when you were under oath back in October of 2025, you admitted to possessing a gun, did you not, sir?
I said a gun was handed to me.
So that's possession, right?
Yeah, but not of a firearm, sir.
You admitted to possessing a gun. The question that I asked you was, what did you do with the gun? And what was your response, if you recall?
That I gave the gun back.
Okay, thanks, sir. You didn't say anything about a towel, and I didn't know what was in the towel, and he handed it to me in the car. You didn't say anything to that effect, did you, Mr. Johnson?
Sir,
No, yes or no, Mr. Johnson? You got an attorney who can allow you to elaborate.
Yeah.
Here's how it's gonna go. Either you answer yes or no. I'm gonna ask this judge to instruct you to answer yes or no. You don't get to dictate the rules. I know you have a lot that you want to say, but that's not how it works here in court. Okay?
He's
Understood?
coming off too hard.
Thanks. Now, previously, you've been convicted as a felon, right?
Yes, sir.
I mean, we talked about your 4 years in sentence for the evading.
Yes,
But
sir.
you're also a two-time convicted felon, right?
Yes, sir.
You've also been convicted of robbery, all right?
Yes, sir.
Convicted of robbery twice, once as a juvenile for which you were adjudicated, right?
Sir, no, I don't remember that. No, sir.
Not something you would remember.
No, sir.
Okay, so if I introduced evidence or court records later that indicate that you've been adjudicated for robbery as a juvenile, then that you would dispute that?
Objection, improper character evidence.
Overruled.
Would you dispute that? Those records?
That I was adjudicated for.
As a juvenile, robbery, yes, sir, that's
I
the
don't
question.
remember that, sir. I would refute it, but I don't remember.
All right. And you were also convicted for robbery for an incident out of around 2015, correct?
Yes, sir.
And you were also convicted of a theft offense at around 2012, correct?
I was. Yes, sir.
And you today want this jury to believe your word, the word of a three-time convicted felon and a convicted thief. Is that what you want this jury to do? Yes or no?
What do you mean?
I'll ask it again. That's a fair thing. If I ask you a question and you don't understand it or you need me to repeat it, I'm happy to do that. Just let me know. Mr. Johnson, here's the question. You want this jury today to believe the word of a three-time convicted felon who's also been convicted of theft as well. Is that what you want this jury to do?
I want the jury to know.
No, yes, sir. Judge, I'd ask that the court respect this witness to answer yes or no.
Mr. Johnson, just answer the yes or no, please.
Yes, sir.
Oh, thank you, Mr. Johnson. With regard to that robbery conviction, I want to ask you about that robbery conviction from 2015 in the context of the quote unquote code you and your attorney talking about. I understand this code that you operate by or operated by means that you don't, and I've tried to make notes as you define, you don't go after somebody that's bigger than you or, you go after someone that's your same size or bigger than you. Is that how that code works? Or work?
Yeah, when we was young.
Yes or no, Mr. Johnson? I know it may be difficult for you. Is that how that code worked?
That's how it worked.
Yes, sir. Now, the indictment in that robbery case says that you obtain or maintain control of property by causing bodily injury to a Hong, H-O-N-G, Hong Nguyen, Nguyen, by striking Mr. Nguyen about the head and body with your hand and an object that was unknown. My question is this: was Mr. Nguyen your size, or was he bigger than you, according to the code?
It wasn't a man.
Wasn't a man?
No, sir.
Oh, was it a female?
It was a female.
Okay, so all right. Was Miss Nguyen your size or bigger than you?
She was smaller than me.
Oh, is that a violation of the code?
No, sir.
Okay. Now, you also talked about tax collecting, your words. Were you collecting taxes from Miss Nguyen at that time? Yes or no?
No.
Okay. What is merchandise? The merchandise that you referenced as part of the argument there in the Amigos parking lot.
Merchandise? A woman.
Okay. And that's what the part of the argument was about, right?
That was his question to me.
Okay. Now, in the excerpt of the transcript that your attorney entered into evidence, you stated a couple of things. One of those things I'm referring to page 7, line 19, is that I've never been one to carry a weapon ever. Apart from the allegations in this case, if a Daryl Wayne Cooper says that you used a weapon to rob him, would that be inconsistent with what you said in this transcript?
It would be false.
Okay. You also said in this excerpt of the transcript on page 8 that that's why I've never been charged with robbery. Is that a true statement or is it a false statement?
No, well, it's a false statement.
Okay, so you have been charged with robbery.
I have been
You charged with robbery twice.
I don't remember the first one, but I have been charged with robbery, sir.
Yes, sir. So when you said that under oath, you actually lied under oath, right?
Well, actually.
Yes or no? Was
No,
it the
sir.
truth?
No, sir.
No. Was it the truth?
Was what the truth?
When you said you've never been charged with robbery.
Well, y'all asked me about my history. I told y'all I was charged with robbery before.
I'm just reading your words, okay? Listen to what I'm saying. Your words. That's why I've never been charged with robbery. In October of 2025, you are testifying under oath that you've never been charged with robbery. Was that a truthful statement?
If I meant it like that, no, sir.
It's not qualified. Yes or no? Was it truthful when you said in October of 2025 that you've never been charged with robbery?
Not at that time.
Okay. And you were under oath, weren't you?
I was under oath.
Which means you lied under oath, correct?
I don't think so. I mean, the way you're saying it is you kind of reworded it, but you asked me before about my history.
Judge,
I told you I had a robbery.
I asked that you answer. Just answer.
It's already been answered.
Okay, yes.
Next question.
Yes. So having lied under oath back in October of 2025, again, you want this jury to believe your sworn under oath testimony here today.
Objection.
Objection or objection.
Call for roll.
I want them to believe the truth.
Yes or no? Do you want them to believe your testimony today?
Yes, sir.
All right. Pass the witness, Judge.
Wilkerson?
Just to clear up a few things. Well, when we talked about you using the word never charged with. So in terms of the issue with the 2015 matter, was that the matter you testified to that was born out of trying to get diapers?
Yes, sir.
And maybe I misheard you, but can you clarify for me what was that individual on the video asking you about?
Merchant, I guess he was someone that sell women, and he was asking me about if I wouldn't pay him, talking to his merchandise.
So he was, is it the case that he approached you because you were because a female was involved in a conversation that you were having?
Well, no, he approached me because she gave me a hug and told me happy birthday. And I want to say that's why he approached me, because we weren't just having a conversation.
And so when he approached you about having hugged his woman, how did you take that?
I think he kind of stunned me. And like I said, he just looked like, what are you talking about? And then
Judge, I would object to this line of questioning. It's already been asked and answered, and plus, it's not true redirect. In other words, it's addressing what I addressed on the rate, it's not addressing what I addressed on my cross-examination.
That's a federal issue. But it has been asked and answered, so go ahead to something else, please.
You were asked about a number of times that you had an opportunity with the detectives in the first investigation, as well as a number of times that you were asked on the stand back in October of 2025. Just like, well, first of all, in terms of the questions that you were asked by the state's attorney back in 2025, was it the case that, much like today, he was demanding you answer only specifically in yes or no answers?
Yes, sir.
And so, just like today, was it the case that there would be a premise stated and then you would ask to answer either yes or no?
Yes, sir.
And so, in answering a question honestly, is it the case that with regard to some of the questions, you understand why there may be some conflict, but are seeking to explain what you meant?
Yes, sir.
At the same time that you could have said, well, when you were asked about it being a gun, you didn't have an opportunity to say that it wasn't a firearm, at least under cross-examination by the state's attorney, right?
Yes, sir.
And at the time that you were interviewed by the detective, was there any indication that you were being investigated for unlawful possession of firearm by felon?
No, sir.
In fact, again, that charge arose after you were acquitted for the murder.
Yes, sir.
I can see this guy winning this charge. He's not a.
And when you were questioned by
pillar
the
of society
detective
on behavior
in that
wise,
case,
but
were
I
you
can see him winning.
informed of what the investigation was focused on?
Yes, sir.
And again, and I asked you, but I wanted to ask you in the context of being informed of what the investigation's focus was. You were never informed that there was an investigation into unlawful possession of firearm by felon, were you?
No, sir.
Daryl Cooper, let's talk about him for just a minute. Have you had an opportunity, and we'll see if he's called as a witness. There was an investigation in that case. Is that correct?
Well, I'm not sure. So they asked me some questions. I answered them truthfully. I don't think they ever really just extensively investigated it.
Okay. In that case where the state is accusing you of having robbed Mr. Cooper at gunpoint, there was security video. Is that accurate?
Yes, sir.
There was also a 911 call. Is that accurate?
Yes, sir.
And in either of those,
Judge, I would object to any testimony about a video or 911 call that has not been entered into evidence first. There would not have been the proper predicate laid for either of those items for this witness to testify to.
Sustained. I mean, he didn't make the 911 call, correct?
no, he did not.
Okay.
And in that case, well, did you have a firearm?
No, sir.
Did you threaten anyone with a firearm?
No, sir.
Are you ever seen with a firearm?
No, sir.
Are you ever seen with a gun?
No, sir.
You ever seen threatening somebody with a gun?
No, sir.
Did you threaten anybody with a gun?
No, sir.
Did you have a gun on you?
No, sir.
You have a firearm on you?
No, sir.
Did you find, well, um, it was characterized during cross-examination that you lied under oath. Your word choice or your use of legal terminology, is that as clear as a lawyer's or attorney's?
Could you?
Sure. Are you trying to convey what you know to the best of your abilities?
Yes, sir.
And so, in discussing your criminal history and discussing matters where allegations have been made against you at any point, so up until this allegation for murder.
Objection, ladies and gentlemen.
I mean,
Finish this. Finish your question.
so up until this allegation for murder and the allegation regarding Mr. Cooper, had you ever been charged with any weapons offense?
No, sir.
Had a weapon ever been found to have been involved in any offense of which you've been charged, investigated, or convicted?
No, sir.
Remember, this jury, a lot of them raised their hands and said, I'd have an issue. I'd need to know if it was a firearm or a
Mr.
BB
Johnson,
gun
when you were
or a paintball gun.
investigated for murder, you admitted to having a gun, right?
A gun, yes, sir.
All right. And now that you're being prosecuted for unlawfully possessing that gun, you're denying that you possessed the gun.
I'm denying that I possessed a firearm. I've never told you. I've told you that he handed me a gun. I'm not sure if it was a firearm.
Yes, and no. You're denying that you possessed the gun now that you're being charged or prosecuted for unlawfully possessing a firearm.
No, sir.
That's what was judged. Thank you.
Anything else?
Get your hands off my Mountain Dew. Carries it like a trophy.
When
back
you
to the
were
table.
during the investigation, you were just asked if, well, it was actually, you were asked a question if you were being prosecuted for unlawfully possessing a gun. To your knowledge, is that a legal or illegal offense, as the term gun is?
Objection, asking this witness to opine on the law or on the
To
legal
your knowledge.
issue.
Yeah, you need to rephrase that if that's sustained.
All right. When you were the state's attorney tried to lock you into answering a question about being charged with unlawfully possessing a gun just now, right?
Explain your reason.
Was the testimony from the prior exchange when you were cross-examined by the state's attorney very similar in nature, where you were asked to give a yes or no response?
This has all been asked.
Testimony.
Have nothing further for this witness, yes?
Step down, sir. You may call your next witness.
Defense.
I'll call Detective or Officer Carmouche.
All right, Officer Carmouche.
Defense calling an officer. Okay, this is going to be good. Great. The sway, sir.
Good morning. You can have a seat. Officer Carmish is still under oath.
He's back.
And I don't know if, just based on what the instructions were yesterday, you can go ahead and let Officer Carmouche know that other things are being discussed today after your client's testimony.
Okay. So the defendant has testified in this case, and so the nature of the underlying investigation or the prior investigation to this case has now been disclosed. When you interviewed the defendant with regard to investigating the murder offense, I asked you if that report contained anything about unlawful possession of a firearm by felon. Did you ever question him about a firearm, or did you use the term gun?
During our interview?
Yes.
I believe so. I believe that came up somewhere.
Gun?
Either or, the vernacular.
Well, they're two different terms, aren't they?
Yes.
Right? There's BB guns, right? There's paintball guns, right?
Yeah.
There's airsoft guns. I think those are BB guns, actually. There are
They're
pellet guns, correct?
Somewhat.
All right. There are dart guns.
Yes.
Okay. On the other hand, what is the legal definition for firearm?
A firearm that shoots a projectile that has the ability to cause serious bodily injury or death.
So, is there a requirement that to be a firearm, a projectile
must be powered by,
be projected,
propelled by,
by combustion or an explosion?
Yes.
Does that require gunpowder?
Yes.
So, for instance, a rail gun would not qualify, correct?
Correct.
BB gun would not qualify, correct?
Correct.
Even a BB gun that's shot using compressed air would not qualify, correct? And all of those guns, though, are capable of causing serious bodily injury, correct?
They're capable.
You could have asked the defendant if he had possession of a firearm, correct?
I could have.
Yes. You had that opportunity, correct?
Yes.
When you were questioning the defendant about the murder investigation, did you admonish him that he was under investigation for unlawful possession of a firearm by a felon?
Not that wasn't using that charge. It was the interview. It was the murder charge that I was investigating.
Right. So the purpose of the interview wasn't related to a firearm charge at all, right?
Oh, the firearm was used in the murder, so.
No. When you say the firearm was used in the murder, you are saying a firearm was used in the murder, correct?
Correct.
And there were actually two defendants charged with murder, correct?
Yes, sir.
And this defendant has been acquitted of a murder charge, correct?
That I'm aware.
All right. And then immediately after, you submitted a complaint regarding unlawful possession of a firearm by a felon?
Yes, sir.
And you did that before you even ever saw a transcript, correct?
Correct.
Why did you need to, if it was about prosecutorial discretion, why did you need to submit a new complaint in the offense report?
Well, usually whenever we're doing, it's common practice, if we're doing like a murder case on somebody, you don't want to stack in small charges on top of that and, and muddy the waters. So since the larger scale was acquitted, we charged them with the crime that we knew he did.
You say you knew he did. Well, let me ask you this. You testified previously that you talked to Ethan Smith, correct?
Correct.
So the state could have easily called Ethan Smith as a witness in this case, correct?
If they could find him, yes.
Does a robbery charge without a serious, without an item or weapon used that has the ability to cause serious bodily injury or death, that a crime that, well, let me rephrase this question.
Please do.
A robbery charge that isn't aggravated doesn't involve the use of a firearm, correct?
Are you saying that the regular robbery charge does not include a firearm?
That's correct.
What you're asking? Yes. You're correct.
Likewise, it doesn't, a regular robbery charge doesn't include a knife.
No, sir.
Doesn't include a baseball bat.
No, sir.
Golf clubs.
No, sir.
All of those things could cause serious bodily injury, correct?
Of course.
And so if there had been a weapon such as one of those items used back in 2015, then he would have, the defendant would have been charged with aggravated robbery.
That calls for speculation on part of this witness as to what charging decision was made.
Sustained.
Are you aware of any of the facts related to any of the defendant's prior convictions?
Other than criminal history given out, that's it.
Okay, so nothing specific about that criminal history.
Yeah. Yes, sir. No transcripts, no reports or anything like that. Just from what the state and national database gave me.
House please.
Sorry. Officer Carmouche, when interviewing the defendant shortly after what was witnessed on the Amigos video in September of 2024, at any point did the defendant, Romeo Johnson, say that he possessed a BB gun?
No, sir.
Did he say he possessed a paintball gun?
No, sir.
Airsoft gun?
No, sir.
Dart gun?
No, sir.
Or a pellet gun?
No, sir.
He knew that he was in there to be interviewed about a murder, and he knew that that murder was caused by a firearm. Right?
Objection, lady.
That is a leading question. I'll rephrase it, Judge.
Thank you.
He was there for a murder investigation, right?
Correct.
Wouldn't you think it would be important information to mention if what was possessed or alleged to be possessed by him was not in fact a gun or a firearm?
Objection calls for speculation, Your Honor.
Overruled.
Wouldn't you think that would be important information to relay to law enforcement?
Very.
In a very high level and in summary, in a brief form, I want to talk about since we're here on a unlawful possession of a firearm, I want to talk about the links in that murder to the possession of a firearm. And I just want, we're not here to try that murder, so I just want to do it at a 30,000 foot level. Starts out at the Amigos.
Your Honor.
Yes.
Sorry, I got a little scam call that I got a little heated with during that. I missed what just happened. He's allowed to, it's cross. Can't he lead? He can lead. This is a case where I could see jury nullification. I can see the jury finding not guilty based on not proven. The gun versus firearm. The state has had no evidence to prove the firearm. There's going to be a definition read of a firearm that a firearm is, fires a projectile using combustion, using gunpowder. The state has not proven that part. If you can't prove that it was a firearm, how can you say that it was a felon in possession of said firearm? It seems like a basic argument. I don't think, I'm not happy. I'm not trying to defend the dude, right? The defendant called it a firearm. No, he called it a gun. He never said firearm in any of his testimony. I've got 4 or 5 gums in my that I own that are not firearms. They look like them. they project a projectile, but under the terms of this law, they're not a firearm, and a felon would be able to own them. It's a detail, but it's an important detail that the legislature in Texas put into law. I think there's reasonable doubt for sure. There was no firearm found. They never found it. Tell you what they did find, and I don't know because I didn't watch this case, but they did find somebody who got shot. But it wasn't on video, at least not that we've heard. Judge, can you let us back in? Come on, Judge. It's getting hot in here, says the prosecutor to the witness. He's wearing a bulletproof vest.
No.
Hello.
Judge, come on. Maybe approach. Are you going to turn the sound back on for this? We're going to have to check with Texan about what happened here. That necktie. Defendant's necktie, I'm just going to go out on a limb here and say that tie has not been untied in many a year. I believe that is not that it was been put in place there. I don't know, maybe by his dad when he first got the tie, and he has not untied it. He just loosens it, takes it off, and then tightens it back on his collar again. Judge, let us hear.
What you believe to be a firearm possessed on the video. Defendant gets into that blue Chevrolet Malibu. The license plate on that blue Chevy Malibu. What, if anything, comes of that shortly thereafter?
During my investigation, that was the early infancy stage of our TCC real-time crime center.
Speak up just a little bit. I want to make
Sorry, that was the infancy of our real-time crime center, and so it was just starting up, and we had license plate readers, and that's when we started tracking its movements.
All right, and the real-time crime center tracked the movements of that Chevrolet Malibu from the area of Amigos Food Mart to the area of the 2200 block of Ayden Street, correct?
I don't.
Objection, leading.
I'd have to look.
It's cross.
I'd have to go back but it was in that area. I know that.
And in the early morning hours on September the 14th of 2024, was there a murder in the area of 2200 Ayden Street?
Yes.
Yeah. Do you recall if the victim's name was Ronald Barnes?
Yes.
What was the method by which Ronald Barnes was murdered?
Gunshot wound.
Not by BB gun.
No, sir.
Not by a paintball gun.
No, sir.
Not by airsoft gun or dart gun.
No, sir.
But by a projectile that came from a firearm or a gun, correct?
Correct.
And this real-time crime center tracking of that Chevrolet Malibu, we're not talking a matter of hours. How much time elapsed from the Amigos video to the time where that Malibu was put in the area of the murder of Ronald Barnes?
Objection, relevance to this matter.
Overruled. Go ahead.
I don't have the approximate times with me. From what I recall from my memory, it was somewhere within 20 to 30 minutes, give or take estimate.
And was there some cell phone or Google location data obtained from this defendant's cell phone or a cell phone associated with this defendant?
Objection, relevance, and mischaracterization of the underlying facts.
Scope.
Overruled.
Was there some Google location data obtained from a cell phone linked to this defendant as it relates to your investigation?
Yes.
And what, if anything, did that cell phone Google location data show?
Objection, Your Honor. Relevance and beyond.
The door was open to this underlying offense. Again, we're not retrying it completely, but I think the door's been open and Mr. Coleman has an opportunity to get more information about it.
Your Honor, I believe this is misleading. Objection under 403 because of the location data in that case.
Overruled.
Location data, what did it show?
Location data showed that Mr. Johnson's phone was under the the Google warrant basically got me a address and placement of the phone, and it was from satellites down to the phone, and it put it in the area vibes during this time window of when they left and then when the murder occurred.
And my last question or two is, Ronald Barnes, your investigation, Ronald Barnes, what if any illegal activity was associated with Ronald Barnes?
Ronald Barnes, he liked to sell synthetic marijuana. Him and his brother were bottom tier drug dealers, but they're in their 60s. I believe they were in their 60s, and
60-year-old bottom tier dealers,
and just making money that way.
Are you familiar with the term drug rip?
Yes, sir.
Explain to the jury or the jurors who aren't familiar with that term, what that means.
Objection, relevance, and 403.
sustain it eventually. You can't just go down forever.
Mr. Coleman, I think we're probably about as far as we're going to go down that path. Sustained.
Finally.
That's what I'm sure.
Mr. Wilkerson.
I want to be real clear about this Google warrant that was just asked about.
Yes.
First of all, in that underlying trial, the state alleged both that the flock cameras were tracking the car that the defendant was in, and that the cell phone keys that were allegedly linked to this defendant were in two different places at one time, didn't they?
That they were both in two separate places at one time, the phone and the car.
Yes.
Yeah. Well,
right? Because you can't be in two places at once, right?
No.
And the cell phone data that you're talking about shows a steady signal, right? In fact, there are multiple signals from that warrant, right?
I remember there being an issue with that and the fact that how the signals came back and everything like that.
Okay, there were multiple devices detected in accordance with that warrant, correct?
There were in the high teens number of one device tracked and one that was not.
All right, that warrant requested geofencing data, did it not?
Correct.
All right, and geofencing data is very generalized data about devices in a particular area, correct?
Correct.
And that warrant returned did not include anything linking the devices that were detected to this defendant's phone, did it?
The warrant requested was for the Gmail account.
No, Detective, the warrant itself that was served did not mention the Gmail account, did it? Only the affidavit mentioned the Gmail account, correct?
I do not recall.
You don't recall now?
I don't have the paperwork.
Wow, defense getting hot under the collar. It sounds crazy. I mean,
Let me ask you this while we're getting this. The affidavit for the search warrant, that isn't served on the company that is served with the search warrant, is it?
One more time, I'm sorry.
The affidavit, right, the application for a search warrant, that's not served on a party who's served a search warrant, is it?
Forgive me, I'm just trying to understand how you're wording this question. Another way you can word it, kind of.
Yes
sure,
or no?
Please, I'm sorry.
Yes or no?
When a party is served with a search warrant,
yes.
The only thing that party receives is that search warrant, correct?
Correct.
It's been building
not
up to
the
this.
affidavit associated with the warrant, correct?
Correct.
Right. And so in that search warrant, the defendant's Gmail account is not listed, is it?
Well, I have the paper in front of me, sir.
Google it fast, sir. Refresh recollection. You can use any document to refresh their recollection. You swipe me too hard, you can't find it. Found it. May I approach?
All right, approach the witness, Sean.
Sure.
I'm gonna show you what words to, yes, sir.
So that's, if you're showing him something that's not gonna, it's off of a computer.
I don't have a copy of it actually on mine.
You know where I'm headed with my objection on that, Judge.
I mean, how are we?
It's a search warrant that this court signed.
We've already, so I think the search warrant issue has been, it's as far as we're gonna go down the search warrant issue. You've made your point clear that there was a potential issue. That's as far as we're gonna go. We're not gonna, we can't admit something off of a computer anyway, so.
Judge, this witness testified that search warrant return was linked to that defendant.
You've already gotten. Ask another question.
Was that a lie?
The defendant was acquitted in the murder, wasn't he?
Correct.
And you can commit murder in a variety of ways, can't you?
Yes, sir.
And when asked, the defendant indicated that that he, I believe that you asked about a gun, not a firearm, correct?
That's all been asked and answered.
All right.
Move into
So
something
the
different.
defendant said that he gave the gun back to its rightful owner, Ethan Smith, correct?
I don't believe he said that.
Can you explain what double jeopardy is?
Objection.
No.
Yeah.
Sustained.
Yeah, that's not going there. You can't do that. He doesn't want to be done, but he has to sit down. He's been blocked on every avenue.
Can a separate act be relied upon as evidence of guilt in this case?
Judge, that sounds like some legal supposition. Who's asking this witness to?
Sustained. The jury will be instructed about any other bad acts, and so that instruction will be in the charge. They'll have that definition and instruction.
That defendant, first he was at the Heritage Inn that evening,
Judge,
correct?
this is a leading question by a witness that he has
Sustained.
stand.
This witness is adverse to this party.
He
Or
hasn't
he was
answered that.
questioned. He was crossed in his initial testimony.
I'm not going to find that he is adverse at this point.
Whoa.
Is there a home in the area of Ives where gambling takes place?
Objection. Relevance.
Sustained.
The state has alluded to or alleged that the defendant was in the area. Over objection.
I'm going to let you go very short down that path.
Is there a home or essentially a gathering place in the neighborhood associated with Ives where people gather to gamble?
There are several homes, but I know that you're alluding to the one off Primrose, right?
That's correct.
Correct. Yeah, there's one on Primrose.
And did the defendant advise previously that he was at that home or that location at some point during that evening?
He advised that he showed up there in the vehicle with the other defendant of that case.
Passively.
Anything else?
It's pretty good, Judge. I was going over this whole business about the block camera or license plate reader showing the vehicle being in one location when the defendant's cell phone data showed him being in another location. What was the ultimate determination for that discrepancy, sir?
Objection, Your Honor, approach.
You want
Please turn the mic back on, Judge. Please turn the mic back on.
Prior testimony, Your Honor. The witness specifically said that someone else had told him that maybe it was because we're sending jury out. This witness previously told
Who does this make you talk about it? Okay. Here's what we're done. We're done with going down the path. I told y'all it's gonna be evening. We're done.
I think it's already been muddied up.
I think it's
She done.
discrepancy. Cell phone was down, and it was up.
Trying that case again. I've got him not willing. We're done. I don't think that gets us fully into these with this judge.
We're done.
Nothing further, please.
All right, thank you, sir. Your excuse.
Now the defense rests. What do you got? What you got?
Any other witnesses?
Defense rests, Your Honor.
All right, so ladies and gentlemen, let's take Mr. Coleman, Mr. Wilkerson, y'all come up for a second.
It got spicy at the end. It got spicy at the end.
You have rebuttal. Any idea how long that'll take? Do you want to take a break and then do it?
Just scheduling
I mean,
here.
it'll take maybe just a quick.
They'll spend a lot of time.
Okay, all right. So let's do this, ladies and gentlemen. We're just going to take kind of a late morning break. And so go ahead and have some. It's 11:15. We will get started at 11:30. Keep in mind all of the instructions that you were previously given. If everyone else, please remain seated. You're excused for about 15 minutes.
All right. We are finally going to be able to catch up just like the 2 minutes that we're behind in the break as the jury gets a little bit of a break. We're going to zip ahead. Just 1 second. Zoop. There we go. All right. Well, it's time for a poll. It's time for a poll. And, we might have a verdict here before you know it. See if I spelled everything right so I don't get roasted in the comments. I think I did. I'm going to use all caps here so you guys don't choose the wrong one. Read the answers. Read the answers. We're doing, has the state proven the charges? Has the state proven? So we'll see. We'll see where we are. We're about 50-50 right now. So cast your vote. It's important. Could have a significant impact on the outcome of this case, if you were a juror at least. Start a third option, including I misclicked. That's the next poll. How many of you misclicked? And then we hope that you don't misclick on that one. Carler, I'm hearing this. Just for me, I wish that this case was heard in front of a different judge. What is going on in the courtroom? Everyone's talking over the case. Can you imagine if this guy walks on this charge? Can you just? I don't know if he did it or not. Honestly, it sounds like all the other stuff is irrelevant. We're not retrying the murder charge. He was acquitted for that one. A jury of his peers found him not guilty. So I'm keeping that aside, and I'm not deciding my opinion on this one based on that. I just am looking at this particular charge, saying, how can you prove it's a firearm? Isn't that something they have to prove? The state has to prove the elements of the charge. How do you prove it's a firearm? Well, he said gun. Is every gun a firearm? No. Then how do you know the gun he had was a firearm? I don't know if you can get there. On that alone, I'm going to say I'm going not guilty. This will be amazing. Amazing verdict. We get a verdict on hump day. The top poll should be, I didn't read the answers, or I failed to follow instructions, or something. The jury did see the video. That'll help them. That'll help them. But that won't help them answer the question of whether it's a firearm or whether it's something that looks like a firearm. And it's not illegal in Texas for him to carry something that looks like a firearm. I'm not even getting into the constructive possession or whether or not it was fleeting or something else. He said he had something that he didn't even know what it was, looked like a gun, that he gave back to the guy. So his testimony, if he doesn't know it's a firearm, I don't know how anybody else can know it's a firearm without any additional information. Interesting. But he committed a robbery with this item in his possession? No, he didn't. The testimony was he did not have that in his possession. The only conviction he has for robbery was without a weapon. We didn't hear the one. Well, we have a disputed one from when he was a youth, but that he says he doesn't remember, and that was not admitted by the state as a juvenile. If it walks like a duck, quacks like a duck, it's a duck. Not believe much of his testimony, though. So I have to ask you just, Stephanie, which part do you believe? Do you believe the part where he said it was a gun, but you don't believe the part where he says, I don't know if it wasn't I don't know it was a firearm. I have no knowledge of whether or not it's a firearm. Can you clarify the charge here? He's charged with possession of a firearm by a convicted felon. 4 years ago, he was convicted as a felon. For 5 years, he can't be in possession of a firearm. In this video, there's images that make it look like he has a gun, some sort of pistol. Could be a BB gun, could be an airsoft gun, could be a pellet gun, could be a replica cap gun, could be a prop gun, could be all these things. The police never found it, and they don't have anyone that says what it is. All they know is that later that night, there was a murder, and that person was shot. So they're saying you were in possession of the firearm. He was found not guilty of the murder. It's interesting. The question is, reasonable doubt. Does it get you beyond reasonable doubt? Got a couple minutes here before they come back in and kick this off again. He's not a fool. I don't know. He says he's never been a gun person. He's never had guns. Wasn't raised around them. Didn't use guns. I can definitely say I've met people who have never held a gun before and wouldn't know which one was real and which one isn't. He says he's never shot it, doesn't know how it operates. This does feel like double jeopardy. I don't know about double jeopardy as much. Uh-oh. Text Ann. Members of the jury are talking about the plaintiff's lawyer. Should they be doing that? I don't know what the instructions were, but generally they're not allowed to talk to each other. So I would stay away from them. They should not be talking about this case yet. I would say no, but stay far away. I will say, Texan, if you let the bailiff know, you might be called as a witness. Just heads up. Yeah, just Stephanie, I'm with you. This guy is not a model citizen. By any means, he's not something I would want anyone to replicate or follow in the path of. In the whole idea, we beat people up who thought they were tough for what? Because they thought they were cool. Not a fan of that, and it's frustrating sometimes to argue for a position that would benefit somebody who has that mentality, or, but could be a mistrial. And they gone. They gone. Let's go back. Okay, we're waiting for them. Just bounce the feed. I think the lawyer sort of trips over his own feet. The defense lawyer, he gets so agitated and so excited that he struggles to get the statement out, and he's fighting an uphill battle because the court is not doing any favors for him. Zero. They're making him work for every inch of progress that he gets, but he's struggling to.
Ma'am. Right. Let the record reflect state's attorneys present, defendant, and defense counsel are present. Anything we need to take up before we bring the jury in?
Judge, I did not subpoena the 911 custodian of records. I'm trying to find the business records affidavit that was previously submitted with regard to the other pending matter associated with Mr. Cooper, who I believe the state's felt call. And so I will need an opportunity to get that custodian of records here with regard to the 911 call in that case.
Was it filed with the business record affidavit already?
No, Judge, if there was a business record after, I didn't say it. No.
Okay.
If there was one, it may have been included like from the PD with the discovery materials, like all in that.
Gotcha. Okay. Okay. Call. You can bring the jury in. And what I'll do is ask. We'll take maybe an extended lunch break, and for y'all's cooperation to help maybe so that we're not delayed, get whatever we need to do to get somebody here. would be great. Do you have a name?
For the custodian of record.
Yes.
Let's see here. Judge, I will say this. I put Mr. Cooper on our witness list a long time ago. And he's mentioning the discovery records about his involvement in this case, discovery material. Defense counsel had, it's not surprise for him to know, particularly after yesterday, seeing him here, to know that we would be calling him as a witness and that 911 call would be relevant.
I don't disagree with that.
I have the business records affidavit associated with it. I just need the ability to print it.
Well, Judge,
let's get there when we get there. You can bring the jury in.
The whole way that business record affidavit works is if it's on file for 14 days in advance. That's not supposed to.
So
hold on.
Is she going to shut down the 911 call avenue?
All right, let the record reflect the jury is seated, state's attorney's present, defendant and defense counsel are present. Mr. Coleman, at this time, does the state have any rebuttal?
Yes, Judge. State called Daryl Cooper.
All right, Daryl Cooper.
Daryl Cooper.
They said, can we approach, right? Or, no, maybe not. They were calling Daryl Cooper.
And was Mr. Cooper here yesterday?
Yes, he was.
Great sworn. Thank you.
He was one of the officers. Yeah, we saw him before, for sure. He was there.
Good morning. You can have a seat right over there in that chair, Mr. Cooper. And if you'll pull that microphone down right there as close as you can get it, make sure you speak loudly and clearly so everyone can hear you. Also, Mr. Cooper, if it's a yes or a no question that's asked to you, please say yes or no and not just a head nod or an so the court reporter can get everything down.
He's not an officer.
Thank you. And you are under oath still from yesterday as well, correct?
Yes.
All right, you may proceed.
Good morning, Mr. Cooper. Would you please state your full name for the court reporter?
Daryl Wayne Cooper Sr.
And Mr. Cooper, how old of an individual are you, sir?
I'm 65.
And I saw that you kind of had some difficulty making your way into the courtroom. What do you have going on with your foot? Is it your foot?
I'm disabled. I have no control over the left leg. I had surgery yesterday on my foot.
All right, thank you. Thank you for being here today. In fact, speaking of being here today, you didn't want to be here today, did you?
No, I didn't.
In fact, it was with we had to make some efforts to get you here. Is that fair to say?
Objection.
Overruled.
I'll move on. Judge. I want to take you back to September the 7th, 2024. What did you tell law enforcement happened on that day?
Law enforcement came. Well, at the Heritage.
Heritage?
Yes, motel.
Heritage is a hotel, a motel?
It's a hotel.
Okay, on 11th Street?
Yes.
Here in Beaumont?
Right.
Okay, go on, please.
Okay. The day before the incident happened, I was renting a room.
And renting a room in a hotel.
Proceeding the car to the room, I entered the room and had whiskey while cigarettes. And so I went back downstairs and I told them that the room had been cigarettes. It has whiskey boxes and cigarettes.
Let's do this. I want to get straight to what we are here for. Did you encounter Romeo Johnson on
This is when I encountered him.
Okay, when?
When I went back down to get my resume out of the car.
Yes, sir.
Mr. Romeo was at the door. I said, I have to get the car to the room. And he said, well, you come on in. So no, I went back downstairs. And I told the individual was at the room itself. And she gave me another key. So the next day, I went to go get another room. Mr. Romeo said, let me holler at you. And I said, I just got off work, I'm ready to go. So he stopped me and
I gotta keep your question and answer. Let me ask you this question. Was when he encountered you encountered him the next day, was he alone? Or was
he was with another individual too.
And what did he and that other individual make you do at that point?
The first of all asked me for money because they were using the room and they banded them from the motel.
Okay, and he asked you, the two of them asked you for money, and what was your response?
I said, no, I don't have money on me. I had money. But
I'm trying to keep it moving, Mr.
I understand that, but you have to understand when you ask me a question, I'm trying to give you that answer.
Fair enough, Mr. Cooper. Please go right ahead, sir.
Okay.
So he pushes back.
I told him that I didn't have the money. I said, man, you got us put out to property. So, you're going to pay us. I had money. But he had said, no, he go to me to the side stair. And the other guy with him, they said, come on, you don't give us some money. So I showed him my wallet. I had my money in my pocket. And I said, all I got is my credit cards. So.
And at some point, and I get it, Mr. Cooper. There's rules I got to follow. I'm sorry. I know it's frustrating.
I understand that.
Because this defense can object. If I just let you talk, the judge is going to probably tell me, hey, you just can't let him talk. At some point,
hold on, we're going to get there. Just
there are rules. I got to follow them.
Okay.
Ask the question.
Did the two of them force you or make you go somewhere to another location?
They did.
Yes, sir. And that location was it a Market Basket food store?
It was. That some place had ATM.
Yes, sir. And they wanted you to do what at that ATM?
They wanted me to withdraw money out of my account.
Now, did you willingly want to do that?
Willingly.
Yes, sir. Was it your idea to do that?
Yes, it was my idea to go to Market Basket because they got cameras there.
Okay, but you didn't want to give him money is what I'm getting at, right?
Of course not.
All right. And what, if any, item did you see or observe on Romeo Johnson during the process of them attempting to get you to withdraw money from the ATM?
But they forced me to go there.
Yes, sir.
And they said don't run, you're going down. So the other guy said, Romeo asked the other guy for something, because I was in front. And the other guy said, I got to go back and get something, get mine. So he said, well, give me yours. And I kind of looked at him, said, man, I look back here. He said, what you doing? So after giving.
Hold on.
What did Romeo have on?
What did Romeo have on?
Did you see him with a weapon?
Of course.
All right, that's what I'm getting at. This jury wasn't there, so they need to understand.
Oh,
what you
okay.
saw. What did you see on Romeo?
He had a pistol. He clicked. While I was in front.
Okay. This is while he was attempting to get you to withdraw money from the ATM.
This was while we were going to Market Basket.
Yes. Did you in fact withdraw money from the ATM?
I'm a little bit smarter than that, sir.
Okay. What did you do then?
I pushed the pin in, the wrong pin in 3 times.
Oh, very good. So you intentionally entered the wrong pin number. So then what happened?
After the 3rd time, it locks.
Okay. And what did you do next?
They asked me for my card.
Okay.
So they could try it.
Okay. And then what happened?
I let them use it because it got cameras in it.
Okay. And were they successful?
Nope. The card was locked.
Did you or they purchase any items with the card?
The card was locked.
Oh, I get that. If you told law enforcement that they made you buy like candy or something, is that the case?
The card was locked. But I did not do the matter of fact, the manager, we went to the counter.
Yes, sir.
They said you go to the counter and trust. You know what I mean?
Uh-huh.
And
his story's
I
not adding up.
knew the manager. I'm looking at the manager, and he knows I come there every day because I was saying it for over 2 months.
Let me ask you this. Did you tell law enforcement that they made you buy 2 drinks in the candy bar and ask you to get cash back? Did you tell law enforcement that?
That's what they asked me to do.
But what really happened? What happened?
The car was locked, sir. I intentionally locked the car.
I got it. Yes, sir. And ultimately,
part
did
of
they
locked?
take your
Don't
wallet
understand.
from you?
They did that. They did. I stopped. Matter of fact, they told me, come on. So I know they got camera right at the front door.
Yes.
So I stopped intentionally at the front door and told them no. So one got on one side, one got on the other side of me, you know what I mean?
Mm-hmm.
And I'm looking at the manager, the cash register is right in front of the front door.
Yes, sir.
Now, the manager seen me struggling with the guy, you know, natural assumption, okay, it's on camera, the manager see it, okay, they gonna go.
But
They did not. They drugged me in the parking lot.
But ultimately, they took your wallet, right?
I didn't say that.
I'm sorry. I just want to be clear.
I did say that.
Yes or no, Mr. Cooper?
Yes.
They took your wallet?
They did.
And your wallet contained your debit card and some amount of cash, right?
Though it didn't have cash. I had cash in my pocket.
But your wallet contained some items, including your debit card, right?
Everything.
All right. I'll pass through this. Thank you. Oh, one final question. I'm sorry.
Matter of fact,
Do you see?
Hang on,
Hold
hang
on.
on.
Do you see Romeo Johnson in the courtroom here today?
Of course.
Could you please point to him and identify him by the article of clothing that he's
He has on a green shirt. You know, he's to my right.
Yes, sir. I'd ask the record reflect the witness has identified the defendant, Judge.
The record will so reflect.
I'll pass forward the stretcher.
Mr. Cooper, did you speak with the 911 operator regarding this incident?
I don't remember at this time. Yeah, it's been a minute. And I was stopped. I told her, yes.
So you did speak with 911 operator?
Yeah.
And did you tell the 911 operator that there wasn't a firearm involved?
There was a what?
That there was not a firearm involved?
Why would I say that? No, I didn't tell her that.
You don't remember saying that?
I don't remember saying that.
If you were to listen to that call, would that help refresh your recollection?
I was in shock at the point.
If you listen to that call, would it refresh your recollection about what you said that evening?
I mean, at the time, I knew Romeo. The other guy that told me that.
Objection to the non-responsive portion, Your Honor.
Sustained. Just be sure and answer the question that he's asked, okay?
You never told officers that Mr. Johnson had a gun, did you? Or a firearm, did you?
They did have a firearm. Obviously.
Objection, non-responsive.
Just be sure to answer the question. Yeah.
Okay.
You never told officers that Romeo Johnson had a gun, did you?
I don't recall because I know the other guy did.
You said you know the other guy did.
Yeah.
You mean somebody else with Mr. Johnson?
Of course.
And didn't you say that that individual put his hand inside a bag?
I'm
Yeah.
not gonna argue
Yeah.
with semantics.
And said, give me your money or I'm gonna do you.
Right.
Right? With a hand inside a bag. Right?
Right.
Right. Romeo Johnson didn't say that to you, did he?
He was with him.
He was with him. Okay. And so when you
But he
Hold
had.
on.
Okay.
Just answer the question.
when you say that Romeo Johnson had a gun, you never saw a gun on Mr. Johnson, did you?
Yes, he did.
When?
When he handed him the gun, the other guy handed him the gun and said he had to go back to the motel to get something.
The other guy handed Romeo the gun?
Yeah.
When was this?
On the way, taking me to the market basket.
On the way. I just asked you, did Romeo Johnson have a gun at the market basket, right? Romeo Johnson didn't threaten you with a gun, did he?
Yes, he did.
He threatened you where?
Going to the market basket.
Going to market basket.
Right.
This defendant threatened you with a gun.
Right. He said, don't run.
Don't run.
That's right. Say, don't run. You're going down.
Isn't it true that you had borrowed $300 from Mr. Bello?
From who?
Bello?
No.
No? I'm sorry?
No.
No? Oh, why were you being asked for money?
Well, because reason being, this is where they were staying at.
Mm-hmm.
At the Heritage Motel.
Yeah.
When you get before you check out, the maids open the door and you can allow them to clean the room.
Mm-hmm.
Okay. After 11 o'clock, all you have to do is just turn the deadbolt, and the door doesn't lock. So you can use that room that whole day until that next day, as long as you don't close the deadbolt light and leave out.
Okay.
When you leave out that room, you can get before you leave out that room, you snap the deadbolt lock. The door doesn't close.
The 911 operator specifically asked you if a firearm was involved, didn't they?
I don't remember. That's been the years ago.
Would it help refresh your recollection to listen to the call?
Yeah, it would help.
Your Honor, approach the witness. I don't know if you want to temporarily excuse the jury.
Yeah, we're not, but we can't play it here. Let's do this, ladies and gentlemen. It's 10 minutes to 12. Let's go ahead and take our lunch break. And would like to get started at 1:15. Please keep in mind all the instructions you were previously given. If everyone else would remain seated, you're excused until 1:15.
Half-hour lunch? Is that all we get? Half-hour lunch? Good grief. Judge, I can't make a peanut butter sandwich and eat it in that time.
When are we going to break for lunch, Judge?
Wow. So we're going to have the defendant. Well, the defense team. Well, that's a lot of bright colored clothing there for the jury. Defense is going to play the 911 tape for the witness. He's going to say to the 911 operator.
All right, let the record reflect the jury's outside the presence of the courtroom. So what we'll do is take our lunch break. Before we leave to do that, you can visit with the Mr. Cooper, play whatever portion of that recording you want to. And then Mr. Cooper, you'll need to come back and finish your testimony after lunch at 1:15, okay? And then we'll get you out of here hopefully as quickly as we can after that. Okay, but y'all can visit for a little bit. We'll close court. And then also I have sent you guys a new charge that includes the 2 new provisions. I took out, obviously, the defendant testifying. I added evidence of wrongful acts. I also added evidence of prior convictions. I added those 2 paragraphs. So I need you guys to take a look at that as well. There will not be any delay. If you're trying to get someone here, you need to try to make that happen with regard to any additional witnesses. All right, court will be in recess till 1:15.
All right, so Judge says, witness, mid-testimony, you can talk to the defense. Prosecution should probably step up and just listen. Hey, we're going in the back room. He says, do it here. Trying to figure out where everyone's going. Man. Didn't see your comments. Apologize. Katie Bug, sorry. Your time comments. It's an hour and 50 minutes. Oh, it's Central Time. Thank you. Thank you. I'm like, I apologize. Apologize. Makes sense now. Time zones are hard. All right, let's give Texanne a minute here to see if she can contact us. I blame Josh for this crazy. It's a good one. It's heating up here at the end. We're in rebuttal time. So this is both sides rested. Now this is rebuttal evidence by the prosecution, and this is the cross-examination of the rebuttal witness. They've decided they're going to play it right here. Now prosecution steps up, says, let's give it a listen as well. After this is all done. Yes, please. Texanne was in the courtroom. She's not here right now. They've excused everybody from the courtroom to play this. Yeah, it is lunchtime, so defense attorney playing the audio of the 911 call, probably with with closed captions, I'm guessing. Finally got you to recognize that Middle America has a time zone. We fly over it so much, we just don't think it exists. Texanne says, on my way to my car. We're going to give her a minute. When she gets to the car, she might make us a little call here. Cropper Mom, been absent for a while, but love your channel. No one provides the audio quality you do. It's not even close. Thank you. I take great pride and pleasure in providing the best audio we can for court. We are going to keep the phone lines clean for Texanne, who we think might be calling in shortly, and get her take. What do we need to ask her about? There's a couple times the audio went down with the detective or with the police officer towards the end of his testimony after the approach. That's what it was. All right, yeah. While we're waiting for Texanne, let's do this. Let's make the portal for this afternoon. So let's reuse that. So it's going to be day 2, part 2. And it's going to start at 2 o'clock straight up. Eastern time, which is 15 minutes before they come back. All right. As soon as Texanne finds her car, we'll be in good shape. Use the newest thumbnail. I will put the newest thumbnail on there. I actually changed the old one to be the right thumbnail. I just need to change this new one to be the right thumbnail. Details. Thumbnail. Change. And it's going to be this one. There we go. All right. New thumbnail set up. Live chat. Kim R was first in chat. Even beat Greeners. Okay, portal is configured. Hold tight for Texanne, and we'll listen to what she has for us here.
Remember in the beginning when we started 110 years ago?
Okay, this one's going to work. Still trying to play the 911 call or still listening to it? Here we go.
Call from Texanne.
Hello, Texanne. Oh, my goodness.
Oh boy.
You got a good one. You got a live wire on your hands here. What was this last little session like for you?
It was intriguing. It was interesting. Now, as far as the jurors go that were standing around, like on the way to the bathroom. I asked one of them where's the bathroom, and they pointed the way, which is in like the old part of there's like the old part of the big tall building, and then there's the annex. The courtrooms are in the annex.
Okay.
They were built in 1981, and that's why they kind of look sci-fi. But anyway, the case,
specific. Go ahead.
It looks like a pew. It looks like a pew to me.
Looks
So
like
he was in possession of it.
Okay. The video does look like it. My question is, we've been talking a little bit about this on the channel. There's a distinction between a gum and a firearm. Because there are lots of things that could be gums, but those are not necessarily firearms. And I don't know if the state's proven that it was a firearm. Their most evidence they've got is that later on, 20 minutes later, someone got shot in an area where this guy's phone was. I'm not sure. That to me, that's a stretch.
Yeah. Well, for one thing, he was acquitted for the murder because his phone was a place where the car was not.
Yeah.
The car was there where the murder had taken place. But I don't know how I feel about the flock camera thing though. But that's a totally different subject. But I'm kind of I don't know. It's kind of weird being surveilled all the time. But anyway.
Yeah. Let me ask you this. There was a point where there was an officer on the stand who was recalled by the defense in the defense's case, and they went up to a sidebar, and the defense was questioning him or crossing him. The judge forgot to turn the audio on until the next little sidebar, which was just a few minutes later. Was there anything spicy that you can recall from that time?
Nothing I can really recall. I think, well, he was asking about that. That's what the defendant, was that the defendant that was, the defendant's attorney, Mr. Wilkinson, that was, questioning him?
I thought it was the other one. I thought it was the state on cross.
So it would have been Coleman then. Because at one point, I don't know if you caught it, but when he was getting frustrated and everything, he was trying to bring up. No, I think y'all caught that.
Yeah.
When he was trying to bring up the double jeopardy and
and that got shut down pretty quickly by the judge. And he tried to bring it up another way, and it was struck down again. He got quite agitated. The defense attorney, Mr. Wilkinson, was pacing all over, gathering up his stuff, putting it back down, gathering up, walking around in the well, trying to find his words. He's been able to, like, one of the few wins he's got here, has been able to introduce this 911 call now to the witness. And we've watched while you were out going to your car. It looks like the witness listened to that call. They've since cleared the courtroom. Right. Everyone's gone. But when they come back,
they made everybody clear out.
When we come back,
they made everybody clear out so I was able to hear it.
Yeah, so they could play it in the courtroom. When we come back, he's going to be questioned about that, and it probably says on the 911 call that there was no firearm involved. So I'm curious, is this jury, as they're listening to this last witness, does it look like they're believing him?
Possibly they don't ask.
Yeah.
He may not have mentioned, they may not have asked. So
does this witness come across as believable for you? This last one?
Yeah, he seems pretty genuine.
Okay.
But he's kind of smart as getting the card to lock up and everything.
Yeah, that was a brilliant move. It's like, I would give you money, but I can't. I'm so nervous I could type the wrong pin.
But now they're like, oh darn, we should have checked the pockets.
Yeah, they found out in court he might have had fat stacks of cash with him.
All about secrets, jeez. But the makeup of the jury. Mm-hmm. There are 8 men.
Yeah.
There are 6 women.
Yeah, we get to see them walk in and out because they're shown on the camera. We we saw jury selection as well, but
5 black men. I think there's like 3 Hispanic, 2 Hispanic men and 1 Hispanic woman. But you know that.
Wow.
Yeah.
Can you get any read on? No. Can you get any read on the jurors as far as, you know, who they seem to be following or leaning towards, or is it pretty hard to tell?
It's kind of hard to tell. They are kind of speaking of leaning towards, they all kind of like lean forward a little bit when they go up there for a sidebar to try to listen to see what's being said. You know, you can tell they're like they got their spidey senses on. They're trying to hear, you know, trying to figure out what's being said.
They want all the tea.
I'm surprised. Yeah, and I've got my hair down, so I was able to kind of keep my earbud in sometimes. But you're like way behind what real life is. So I can't really keep it in all the time. But I was kind of surprised that a couple of those sidebars that she actually had the
audio.
She had the audio on. It's just like, wow! Oh, I actually get to hear what's being said.
Yeah.
But that's kind of interesting. But I had to take it out so I could hear like real life going on.
Yep. That's awesome. Anything else you want to share? I know you've got to get some lunch and don't want to hold.
Yeah, and everything's like 20 minutes away, so I don't know what I'm going to get, what I'm going to be able to get.
Oh no.
But,
okay.
The round courtroom there.
Mm-hmm.
Up at the top, you see like the thing, you know, the little bar things that are like heading towards there. Looking at that, it kind of reminds me of like a ship's wheel or something.
Oh, like a compass or a...
Yeah, well, a compass or like a ship's wheel or something like, you know, like where the captain is steering the vessel.
At the helm.
But, yeah, we are like right around the corner from the Port of Beaumont, which does a lot of anytime there's military action going on, we've got a military ship there, like almost all the time, loading and unloading, and we got, you know, military equipment and stuff. And the courtroom rattles. There's times that I thought that my heart was palpitating. I was like, oh my gosh, what's going on with me? And this happened yesterday too. And I asked one of the officers there before the jury came in. You know, I said, "Excuse me." I said, "Do you feel a vibration?" It's just like, "Oh, that's a train going by." There are freight trains that go by, and it shakes the whole courtroom, and it's a little unnerving if you know what's going on.
What floor are you on?
It's on the 2nd floor.
Okay. All right. I'm going to let you go so you can get some lunch. Texanne, thank you very much. I appreciate you being a court watcher for us. Please stay safe and enjoy the experience. I appreciate you on that front. Thank you very much.
All right.
We'll talk to you again soon.
Talk to you in a little bit.
All right.
Bye.
Bye-bye. Thank you, Texanne. We're gonna go to lunch. We're gonna get everybody time to get some lunch because we'll be back in an hour. It's 1 hour lunch. I'm gonna go to the post office. I mean, that's my promise to you here. As long as we have a car. If not, I need to start hustling and hoof it there. It's a bit of a walk. So we might have jury deliberation and even the verdict this afternoon. Could happen. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. We go live again this afternoon with the, I guess it's going to be the final portion of this trial, which is getting spicy. It's getting heated. We'll see what happens. We might have a two-time winner with somebody who beat the charges of murder and possession of a firearm, even though there's a video showing him holding a gun. We'll see what happens. All right, you guys, be good. Have a great lunch. Bye-bye.